listing fine
Recording in progress.
after notice. Clearly write that after notice I लिखी भी दे दो. जोड़ा जो category matter लिखी दे दो.
Lordship, it is directed to listed after 30th of March, but it has not been listed yet.
तो direction दो नहीं सकती है.
In the week commencing after.
Okay, सेटा लिखी दियो. Earlier directed on such and such date to be listed on 30th of March. Lordship, after notice. Please write it for admission or hearing whatever category. Please write it. जो जल्दी आगुल किसी थिबो listing पाए.
We are paying
it can be traced. Why the file is gone? Yes, sir.
Yes, sir. Sir, we are paying for a sir, we are paying for an early posting of this case. As
No preference.
Sir, as because the petitioner is.
I have to prefer why Mr. Das Naik. Anyone I have to prefer. I don't prefer a single advocate. I prefer all. Please appreciate that. All matters are urgent. Out of turn listing, must understand other matters and other counsel are there. How it can be out of turn? Give your memo. Fresh or orders are after notice. Any idea?
No, sir, it's the matter is in family court Puri. The
Sir,
our petitioner is.
I am not the family judge.
No, sir. Sir, we are sorting for a
transfer
transfer of.
question, then speak.
Yes,
Unless you appreciate
sir,
the
we are-
question, sir.
Yes, sir. We are.
You are mentioning a matter before High Court. The matter is fresh orders.
It's a fresh, yes, sir.
So give it. It will be listed. That much I can assure you that matter will be listed, but no preference. All matters have to be listed. Fresh like each other. You do the basic things, sir. You have to write it for fresh
Pardon?
admission.
Pardon.
When did you file the petition?
Hon'Ble, Apex for directed this my earlier hearing. Hon'Ble, Apex for directed. As early as possible, matter may be here.
So please give the reference of the Supreme Court order also, so that why it has not been listed. Honorable Apex Court, where it has directed, kindly give a reference. Instead of making it oral, because you must understand what you are doing now, it is extempore, without any file. So unless you write that, it will be difficult to trace. When did you file the matter? Kebe file kale? Upon kebe file kale?
Sir, file for his.
Hey, Bhagavan, diyon to diyon. अरे सेटा ताकू दियंतु आपण हाई कोर्ट रे किसी केस फाइल करना हती
Yes, sir. TRPC number 312
24 then how it becomes urgent in 26
Sir, because the case is in Puri, our petitioner is.
अरे आपण which language most comfortable you are Odia English Hindi so then why you are not following English today so then how a matter of 2024 has become urgent in 26 that I am asking you
Because petitioner has filed.
ठीक अछि से देखिबे हेडा सर जानना है कि कोन ऑटो नोटिस होइते हो नोटिस इशू होइछ ना हेनी where then why it was kept lying for 2 years because I have been also trying to dig out matters and list every matter diyon ଆପଣଙ୍କର ଯୋଟା ସୁପ୍ରିମ କୋର୍ଟ ଡାଇରେକ୍ସନ ସେଟା ଲଗେଇ ଦଉନାହାନ୍ତି ତା ଦେହରେ
It has been 4 ମାସରେ ଲିଷ୍ଟ ହେଇଥିଲା ତାପରେ ଲିଷ୍ଟ ହବ
अरे सेटा तो मु बुझिली आपण सिपे तो मेंशन बट आपण जदी सेटा काहे की सेटा लिस्ट होनी तो टू नो दैट आपण जदी हेल्प करि पारि यू डोंट हैव द कॉपी ऑफ द सुप्रीम कोर्ट ऑर्डर मने अछि किछि जे रेफरेंस जानछन नला आमे काढियु ठीक है सेतरे गिव सम टाइम आपण मेमोटा आ टिके परे दे आ घंटे परे देबे बट एटलीस्ट फाइंड आउट व्हिच इज द केस व्हाट इज द डेट आपण लिखि देले भी वी विल फाइंड इट आउट फ्रॉम द सुप्रीम कोर्ट वेबसाइट एंड गेट इट Please.
Supplemental list, page 1, 1 to 8.
It's on behalf of Amita Tripathi, item 3, pay for short article.
Your Mrs. Patnaik, Saubhagya Lakshmi Patnaik. So Saubhagya Lakshmi Patnaik on behalf of Amita Tripathi for the petitioner. The matter was presented before this court on 26/10/2022. Defects were not removed. till 21/11/25. On 21/11/25, the matter was listed before the Deputy Registrar Judicial Law Jima, wherein order was passed to remove the granting time of 3 weeks to remove the defects, and the matter was directed to be listed on 15/12/2025. On 16/3/2026, after 4 years, the petitioner, learned counsel for the petitioner, sought for further time to remove the defects. Thereafter, defects were removed and the matter was listed for fresh admission on 7/4/2026. The facts of the case upon hearing the learned counsel for the petitioner, the facts of the case as well as the legal propositions were noted in the order dated, in the said order dated 7/4/2026. The petitioner again had adjournment. As observed in the paragraph 9 of the said order, which is reproduced here. Thereafter, on 4/5/2026, again the adjournment was sought for by another counsel for the petitioner. The earlier adjournments were noted, and the matter was adjourned to give a further opportunity. Today, the matter being in the list for fresh admission is mentioned at the beginning of the day's proceeding. On being asked whether 4 years and 8 months adjournment is not enough for the petitioner, the learned counsel for the petitioner, learned proxy counsel, has no answer. Apparently, the petitioner, after filing the application for the last 4 years and 8 months, has been adjourning. This court has been more than indulgent to allow such series of adjournments. As a matter of though no further opportunity need to be granted, being persuaded by the learned counsel for the petitioner, the matter is adjourned to be listed for fresh admission on on 13/7/2026, indicating that the matter shall be disposed of. Shall be disposed of, having been adjourned, quote karibe, matter shall be disposed of, having been adjourned for 4 years and 8 months.
Your Lordship, item number 7, praying for adjournment because the conducting counsel is not here.
The matter was presented before, the matter was earlier listed on 7/5/2026 and was adjourned at the instance of the petitioner. Today, the matter being in the list for fresh admission is mentioned by the learned proxy counsel. Your name, madam?
Radha Sharma.
By learned counsel, Ms. R. Sharma. Address likhiye, Ms. R. Sharma. MS R. Sharma. On the ground of personal difficulty of the arguing counsel. The matter is urgent to be listed for fresh admission. To grant further opportunity, the matter is urgent to be listed for fresh admission in the week commencing
27.
Satish Sat. Next, please.
Page 2, 9 to,
Page 2, may I be,
9 to 22.
my lord, item 14, I'm praying for an adjournment. My lord, any day next week, actually, 13, 14, 15 bhitar, I'll address your lordship.
Don't know. Ms. Sashwata Patnaik for the petitioner 14. The matter was earlier heard on 4/5/2026 and was adjourned. Today, being listed for fresh admission, adjournment is sought for by the learned counsel for the petitioner on ground of personal difficulty. Accordingly, the matter shall be listed for fresh admission in the week commencing
Satish Sir.
Satish Sate.
12, 13, अच्छा हो, आ गया, ओ प्लीज
Commencing 13
commencing 27
27 ଆପଣ ମନା କଲେ 13 କହିଲେ ଯଦି 27 ତ କୋର୍ଟ ମାଷ୍ଟର କହୁଛ ଏବେ ଚଏସ୍ 27 ବି ହେଇପାରିବ 13 ବି ହେଇପାରିବ
27 थाउ ताले मु टिके
27 yes next
ओ प्लीज माय
The 15 to 22.
23 to 30 31 to 38
35, my lord, it's 2 weeks time too.
35 other side is there
Other side is the state.
inform କରନ୍ତୁ
State.
after notice
I'll inform.
କେବେ କେବେ ଚାହୁଁଛନ୍ତି
After 2 weeks, my lord. The last order that
Santosh Kumar Dwivedi 35 Santosh Kumar Dwivedi for the petitioner opposite party blank. The matter being listed for hearing under the headings for admission is mentioned by the product counsel for the petitioner seeking adjournment. Accordingly, the matter shall be listed for admission in the week commencing
3/8.
3/8/2026.
Item number 26, Your Lordship. Requesting Your Lordship for an adjournment.
26 for orders. Why was seeking adjournment? Other side, Nandi. Please
My lord, I am appearing on item number 26, my lord.
26.
Again. My lord, Mr. Council, my lord, Mr. Ragda sir is call upon me and tell to adjournment. I have no objection. Can you take on next week?
Other side କାହାନ୍ତି କହିଲେ ଆପଣ other side
My lord, I am appearing, my lord.
ଆପଣ other side को ପାଇଁ ଆଚ୍ଛା ये
Again, 26,
ठीक है
my lord.
26 तक कर दियंतु डेट कर दियंतु
Week commencing Satish Sir.
Highly obliged. my lord.
yes call the list
Item 1,
that's 39 years.
39 yes 39 Mr. Further
Yes. Today we are filing the rejoinder. I'm for the petitioner. A friend is for the other side.
39
I'm for the number 3. Open number 3.
39 डेट कर दियंतु
week commencing 10/8.
this month.
हाँ ठीक है आज ही हमें फाइल करते तो कॉपी सॉल्व करते एनी
ये
डे
साथे
एनी डे
ये मंथ रे ताऊ नाही आपणकर 3/8 is the earliest 3/8
Right.
इंटरिम ऑर्डर बोलते हैं
एंट्री मॉडल कोन adjournment थिला
आइए 17/2/2026 रे
what was the entry model
माने if I pay 1 lakh no coercive action shall be taken against me. That was the order of your lordship 17/2/2026 এটা পাস হইছিল
so that order continues
that order particular.
that order remains untouched
Yes yes
yes
must
I mentioned the SLP number and record.
मिलला सेटा आनंतु मेमोटा सेतरे एसएलपी नंबरटा काढी ऑर्डरटा देखि अन्य डिस्पोजल ऑर्डर अछि आपण ताको लिस्ट हे करनी काई तो पदे रजिस्ट्री को आस्थि कोणी तो मु जानि कहि परिबिनी देखियो टिके अलगा रखु मी तो बाहर कर इस आचार्य
Item 24 में थिला से ऑब्जेक्शन को रेटिंग से मतलब मुझे टाइम लेतना जो पैसा देबे के बुझी गेछ मुझे 50 कोन इंस्ट्रक्शन आनी
24 ଟା ଆଉସ ଦିନ ଆସେ ପାଇଁ କହୁଛ କଥା ହେଇଛନ୍ତି ମିଷ୍ଟର ଭୂୟା ଙ୍କ ସାଙ୍ଗେ
ସେଦିନ ଆଉ ଗୋଟେ ମୋର ସିମିଲାର ମ୍ୟାଟର ଅଛି 13 ତାରିଖରେ ରଖି
वी कमेंसिंग 13/7
13
24 वी कमेंसिंग 13/7 डिड यू टॉक टू मिस्टर भूया
ହଁ ସେ ଥିଲେ ସେ ଦେଖା ହେଇଥିଲା ତାଙ୍କ ପୁରା ଇନଷ୍ଟ୍ରକ୍ସନ ପାଇନି
ठीक है से आसंतु देखिबा बट डेट कर देई था
13 तारिख କର
We counting 13. Item 1,
नेक्स्ट पास ओवर कर दो
item 2, item 4,
Dr. Kumar Mahanti for the petitioner. Project party blank.
The petitioner has kindly challenged the order of Hon'Ble Judge Arpela. Hon'Ble Judge Arpela has awarded 8,000 for a wife and 100, 500 for a daughter, copy number 2. And this petitioner filed the RPFM 341/22 before the Honorable High Court. Honorable High Court has remitted back to Hon'Ble Judge Arpela to rehear the case. As per the judgment of the Honorable Supreme Court, Supreme Court had said that the salary of the petitioner 1/4 set up. But the petitioner
Sorry, could not hear it. Last learning of the Supreme Court held that.
Supreme Court, as per the Supreme Court judgment, 1/4 set up.
को judgment.
1/4 judgment.
माने आपण सुप्रीम कोर्ट जज ना मु तो नुह आपण भी नुहंती सो जजमेंट ता कहिबे ना
Judgment मानने मार
ई की कथा
sorry
आई एम एक्सट्रीमली सॉरी दैट आपण सुप्रीम कोर्ट जजमेंट निजे निजे लेखुचंती
नेक्स्ट को सेटा पाइने
को जजमेंट आया मु भी टे पढ़ा पढ़ी करे
ଅଛି
हां 120 माने मु भी 30% भी अछि आज्ञा 30% अछि सुप्रीम कोर्ट कॉलेज 25% अधिक आपण देबेनी
आज्ञा
से जजमेंट मु अपन तो पढ़िनी ये मु पढ़ा पढ़ी करे चेष्टा करे आई कंटिन्यू टू बी स्टूडेंट ऑफ लॉ
मु 800 एक्स्ट्रा था
आपण तो आज आनी थांते
सॉरी मैम
अच्छा यही जजमेंट लोअर कोर्ट रे साइड करथिले
जजमेंट साइड करथिले ऐसे
देखंतु
जजमेंट रे भी से देखिले मु से जजमेंट रे भी
अरे कुहंतुनी
सॉरी
I don't mistrust you but I have to go by the records लोअर कोर्ट रे जो आपण साइड कले कोन फाइंडिंग कोन देखंतु
the petitioner is getting only 10,000 rupees per
आपण प्रश्न उत्तर देबे ना मु जहा पाइबे कहिबे
okay
मु कोन जहा पाइबे कहि परिबेनी I have to confine to your topic your case
minor
आपण जो ट्रायल कोर्ट रे सुप्रीम कोर्ट जजमेंट साइड कले कोन हाउ इट हैज बीन
हाई कोर्ट रे minor ट्रायल कोर्ट रे करना हाई कोर्ट डायरेक्शन
हाई कोर्ट रे कोड जुरिसडिक्शन आसबो
हाई कोर्ट डायरेक्टेड
आज्ञा हाई कोर्ट कोठी अवार्ड दवा पे जुरिसडिक्शन आसबो
हाई कोर्ट डायरेक्टेड टू री
आपण ट्रायल कोर्ट रे जोटा अवार्ड हेला सेटा हाई कोर्ट केबे नो फैमिली कोर्ट कि मजिस्ट्रेट कोर्ट
ट्रायल कोर्ट रे से
ट्रायल कोर्ट रे जो सुप्रीम कोर्ट डिसीजन साइड कले कोन सेटा कोन फाइंडिंग कोन हेला तापर सुप्रीम कोर्ट ट्रायल कोर्ट कोन कंक्लूड कले
ट्रायल कोर्ट रे सही ऑर्डर टा भी कला से कला जे
आज्ञा तो सुनिबेनी से ऑर्डर टा कला तापर तू ता कहिबे आपण को जा पचरा उत्तर देबे ना देबेनी आई रिकॉर्ड दैट यू आर नॉट आंसरिंग
तो
because the advantage is that what you are saying and behaving it is recorded also when you cited the judgment in trial court
Yes,
of Supreme Court judgment that 25% is to be paid
minor
so what happened how the trial court has dealt with that
trial court has disposed of this petition and direct
आगे आपण साइड करछंती ना नाही साइड बुझी परछंती कोन साइड करा हां
ट्रायल कोर्ट रे
साइड जो कले सुप्रीम कोर्ट डिसीजन ना कोठी सेटा केमती साइड कले
आगे ट्रायल कोर्ट रे से अन्य जण कोठला मु करते
पचारंतु कथा होंतु
ताले नेक्स्ट वीक हो
एमिति केस आर्गुमेंट करंतुनी इज अ सॉरी स्टेट ऑफ अफेयर्स the allotted counsel for the petitioner before this court you are Mr. Mahanti
yes madam
we may be casual Mr. Mahanti but not to this extent we are being vast being casual and non-particular has some advantages but largely it is very disadvantageous
sorry ma'am
so why should we be sorry I am not finding am I here to seeking any sorry or apology from you don't do that sir
and next week two chapter over I'll prepare
प्रिपेयर हवा दरकार नहीं है आपण तो देखी ना ब्रीफ आपण ब्रीफ देखते फटाफट मत कहि न थांते जे हां एगा साइट हैला सुप्रीम ताको से एटा डिस्टिंग्विश करले कि रिजेक्ट कर देले कोन हैला अशोक कुमार महांती फॉर द पिटिशनर अपोजिट पार्टी ब्लैंक The learned counsel for the petitioner was heard at some length. The wife, the petitioner before this court is the husband in the marriage. He challenges the judgment dated 21/2025 passed by the learned judge family court Raukela in you kindly take your seat. I'll take some time to dictate. Criminal proceeding number 25 of 2020. By the said judgment, the criminal proceeding was filed by the wife in the marriage and the minor child. Is it about 3 years seeking monthly maintenance under the provisions of section 125 of CRPC? Into bracket, since repealed and substituted by perimeter provision. Repealed and substituted by perimeter provision contained in BNSS 20 bracket closed. The prayer made in the before the Lord Judge Family Court was rupees 10,000 for the wife, rupees 5,000 for the child, and 3,000 towards educational expenses of the child. The petition was favored. However, directing payment of rupees 2,500 for the wife and 3,500 to the child for maintenance and educational expenses. From the date of application, that is 23.09.2020. It is submitted by the learned counsel for the petitioner that as per the law laid down by the apex court, 25% of the earnings of the husband is to be given as maintenance. On being asked by which judgment the Honorable Apex Court has laid down, he has no answer and submits that he would have adjournment to answer the same. The learned counsel for the petitioner is also asked whether such decision was cited before the learned family court, and what was the response, and how the learned family court dealt with the said decision of the apex court. It is submitted that he shall obtain instruction. Para. Perusal of the judgment of the Honorable perusal of the judgment passed by the learned family court indicates that the present petitioner had adduced evidence by examining himself as OPW1, did not mark any exhibits on his behalf. The opposite party wife and mother of the child examined herself as PW1, also did not mark any exhibits. Stop. At paragraph 8 and 8.1, the following has been stated. following has been observed by the page 21 reads, observed by the Learned Just Family Court. Stop. The Learned Counsel for the petitioner is apprised of the law laid down by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the Honorable Apex Court has authoritatively dealt with the scope of revision by High Court in orders, in judgment passed by the Family Court in applications under Section 125 of CRPC. Paragraph 20 of the said judgment is reproduced herein. As sought for, the Learned Counsel has adjournment. The matter shall be listed for fresh admission in the week commencing. As sought for, petitioner has adjournment. The matter shall be listed for fresh admission in the week commencing. 27/20/26. तापरे ता पूर्वुर लिखिवे केते टका देलेनी on being asked, it is submitted by the Learned Counsel for the petitioner that the petitioner have been shut down. The petitioner has not paid any amount towards maintenance as directed. He remains in default of the amount 2500 যুক্ত 3500 तेईस नौ कोड़े पड़ेगा Sentenceটা পড়ুন তো submitted that one. On being asked, it is submitted by the Learned Counsel for the petitioner upon instructions received that he has not paid any amount towards maintenance as directed by the Learned Just Family Court from the date of application, that is 23/9/2020. Stop. The total amount due up to June 2025 comes to 2500 যুক্ত 3500 bracket রইলা into 66 যেତିকি ହେଲା কোড়া গলা আছে ଯୋଉ କାଲି ଯୋଉ ଜଜମେଣ୍ଟଟା ଥିଲା ରାଜେଶ ଯୋଉ ଅର୍ଡର ଲିଖି ଠିକ ଅଛି ରାଜେଶ ଗୋଟେ ପଚାର ଚାଲ ସିପିସି ରେ ଅର୍ଡର 41 କଣ 3A 3 10 11 ସାର୍ ବହିଟା ଦେବେ ଟିକେ ସେଇଟା କଣ 41(1)(3). For the petitioner is apprised of the provisions contained in CPC. Order 41. XLI, then 1 dot into bracket 3. The plural kariyo, orders 3 dash capital A 10 and 11. This is pura complete. This paragraph. The petitioner shall file affidavit. Complete for it. In order to sustain the challenge, sustain the revision before this court, how you will secure the amount due? That is upper exception. Adjournment time. Yes. Yes, next.
Okay.
चलिए yes, next please.
Item 5,
So Vikram Chandra Ghade for the petitioner.
The petitioner is the husband who has challenged the order of the 6 for 2026 passed by the Lord and Family Judge Jasko, where he has been pleased to award them for maintenance of 4,000 for the
Same Mr. as Mr. Bhanti was arguing the same points, same adjournment, same order. ଆପଣ ଡାକିବି ନା କରିଦେଇ ପାରିବେ ପୁରା ଏକା ଡେଟ୍ କେବେ ଚାହୁଁଛନ୍ତି ଆପଣ ଆପଣ ଏଟା କେତେ ଡେଟ୍ କଲେ ଆର ବାଟଟା 4ଟା 20/7 କୁ ଆପଣ ହବ ନା ନା ଅଧିକ ଡେଟ୍ ଟାଇମ୍ ଚାହୁଁଛନ୍ତି
ଡେଟ୍ ମୋର ସବୁ ସଂସନ ହଉଛି ସେ ଲେଖିଛନ୍ତି ଯେ ସାଲାରୀଟା ହଉଛି 13,000
ଆପଣ କଣ ଟ୍ରାଏଲ କୋର୍ଟରେ ହମ୍ବଲ ହେଇନଥିଲି अरे ट्रायल कोर्ट रे हम्बल नथिले कि एठी हम्बल हेले केमति हबो ट्रायल कोर्ट रे कोन कले ट्रायल कोर्ट रे हम्बल हेबे एविडेंस देबे प्लीडिंग्स रिटन स्टेटमेंट देबे
13,200 बोली एडवोकेट प्रूफ होची माय सैलरी इज 13,200
अपन डेलीवेट करतन केते लॉ टा पढिबे आपण कोन आसी क्लाइंट लॉ पढिबे मिस्टर घड़ई आई हैव हाईएस्ट रिगार्ड्स फॉर यू जेतोळे आसी आपण क्लाइंट कहले मोर 13,200 तक डिसीजन टा देखिबे कहले 13,200 आपण बाकी सब काम कर डेलीवेट काम करी की हाँ से जहाँ करेंगे आपण so that should be your stature you are at an exalted position से कहेगा मुझे जानी आएगा मु तो घरे खाए खटरे खाई मठरे शुए so मु आया कौन परिवार पोषण करी so telling the law we are I have all sympathy वे तो मु ताको पर्सनली किसी टंका भी दे दियंती I don't know how much I can contribute but सेटा but can I draw sympathy here de 13,000 टंका पाउची से किछि करि परिबो सी आगे धर तू गोड जाय रे तापर यू सी दैट यू टेस्ट द लॉजिक मु 13,000 टंका रे ग्रहण कर देली तापर जोडे आसे मो या काम कर मु किछि पाए तो हाउ टू हैंडल दैट तो सेति पे सुप्रीम कोर्ट कहिले बा हाई कोर्ट कहिले कि एबल बॉडीड पर्सन कैन नॉट and I am surprised that in Honorable Justice Chief Justice Deepak Mishra's judgment as his lordship then was, he is not being read or followed by us. See, देखंतु आपण से जे सेटा करिवे he might be having an agenda मोर किछ दबार नै but सेथिरे आपणकर किछ रोल नै आगे you are not to aid and assist neither the court can do that सी आगे जदी देबेनी कोन हबो होइतेंती पारे जे ताकर एग्जीक्यूशन जेतोळे हबो फेल करिवो and that is a possibility ताकर किछ नै से कोन करिवे
इंटरेस्टेड भी रखियो पे दियो
सेटा से आर्गुमेंट भी हिची जे आपण जदी इंटरेस्टेड ताले काहे से रहु नांती that is a problem yesterday it was argued your interest to have both of them you will not maintain them कम खर्च हो तो आपण 13,000 रखी परिबे और एथरे कम खर्च रे चल जिवे करि परिबे ना डाक्यू सेट आपण जदी पढी देबे मु डाक्यू आइटम 4 टा पढी दे परिबे पूरा पढी परिबे तो ठीक अछि आपण कर टाइप कर से केस नंबर पकेबे डेट पकेबे सब समान गोटे ऑलमोस्ट इट इज सिमिलर
item 6,
On behalf of Mr. Sahoo Millers, kindly pass on.
so
Pass.
item 8,
आपण पासवर्ड करचंती मिस्टर सुसंपद होता फॉर द पिटिशनर
the petitioner challenges transfer. The petitioner challenges
seeking transfer not challenge petitioner is seeking transfer
seeking transfer of the section 9 restriction of conflict rights that is pending in Baleshwar.
did you ask what is your stand in the section 9 application you want resumption of matrimony or what
Sir, I want that to transfer the matter from Baleshwar to Cuttack just because.
अरे आपण काही त्या भितर पोस्ट you are a lawyer. You are being asked about the petitioner before the High Court. Did you ask her what is her stand in the Section 9 application?
She doesn't want to return back there.
Why? At her age, both of them are very senior. They have seen much of life.
Very senior because there is an.
I mean, reasonably senior. If you say that I am much senior, then obviously I am. They are much younger to me. That's not the point.
My lord,
But at least they have seen life. Why this kind of activity? What is the issue between them?
there is an extramarital affair between the opposite party number 2 and the opposite party extramarital affair. For which she doesn't want to go there. She has a kid of 12 years which starting in Cuttack even. And we are filing a divorce petition in Cuttack even. Please, Madam.
This allegation is made in the Section 9 application.
No.
Then why you are reciting it? You have to be very careful as a lawyer. Can you be just like, I have been using the word henchman or agent? Can you be just like a parrot? Whatever the petitioner says, he will go, say everything in court. You have to have some more thought actually. Whenever you are receiving a brief of matrimonial nature between two persons, you have to be extra careful. You have to look the life, the impact. You have to look at their life, they are leading, and the impact of the litigation. Much more than a lawyer actually. You have to be the friend, philosopher, guide kind of situation. You have to be the person who is approaching you. You have to explain these aspects. What are the priorities and all these? Somebody at the age of 43 with a 12-year-old kid wants separation. Hindu marriage is an institution, it's a sacrament. In many societies, the marriage is given the last priority. Marriage is most uncommon. Relationship is common. Having kids is common, but a marriage is most uncommon. They decide that we will not marry because we are not, maybe we are not in the process of accepting a marriage. But in our society, it is not. It is the starting point. The petitioner before this court is the wife in the marriage. She seeks transfer of the CP number. CP number कितने?
Sorry, 120.
Record लिखी ना? Annexure 1 ने किसी लिखा है नहीं ना? Mention है. CP number 122 of 2026. Pending before the learned judge. Learned family judge Balasore to Cuttack, to the court of learned judge family court Cuttack. Stop. The said CP has been filed by the wife in the by the husband in the marriage under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. He submitted that the petitioner, after her marriage has run into rough weather, stays with her parents at Cuttack, with her mother at Cuttack. She finds it difficult to attend the case at Balasore. Stop. Issue notice along with this order. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. In 3 working days, returnable date be fixed to
10/8/2026.
The matter shall be listed for orders in the week commencing 17/8/2026. If you can work out a settlement, because you see your husband's brother and sister, I mean wife, I mean these opposite parties, brother and the sister-in-law, petitioners, their family will be impacted by this. Whenever a family is in distress, the maternal side of the lady is in distress, the husband is in distress, the child is most stressed. He is at a vulnerable age. He will be seeking his identity as child of some father and mother. Please consider these things. Next.
Item 9.
Item 9, I pray for a Passover, my lord. Mr.
Next.
Mishra.
Item 10.
Your name, sir? Sushanta? Power nahi. File karo to power. Sushanta Kumar Mahanti for the adjournment chahunchu. Sushanta Kumar Mahanti on behalf of Kuldeep Mahanti for the petitioner. Yes, please.
From Marriott of Community Court, Community of Community Court, Marriott of Lana Community Court, Roundhead. In this case, both parties organized clearance in 2023.
Same question as I was, you have been hearing your learned friend, Mr. Gupta. Section and application, what is the stand of the wife? Because by this, in the process, what is happening, section 9, it can't be sent for conciliation, counseling. It is interdicted by this court in TRPC, so it is not. Yesterday also there was a matter where Mr. Prabhas was Jenna was arguing that written statement was filed after the mandatory period of order 8. In this process, actually, we are delaying the matter. If you talk to your client that what is her stand in the section 9, whether she wants resumption of matrimony, you heard Mr. Hota, he says that she doesn't want. Maybe, possibly your client, but what is happening in a section 9 application, it is filed. You filed a TRPC, the matter has to stay, matter has to wait at least, may not be stayed, I am not staying, but at least it has to be adjourned. In the whole process, the parties are not getting the opportunity of counseled by professional counselor. The attempt of the legislature to make counseling mandatory in Family Court Act, Hindu Marriage Act, is in this way getting frustrated. Delayed, then frustrated. You can say, no, I may not be frustrated. Early counseling has an impact. Otherwise, the feelings get crystallized. Notice. You have to make the change. Actually, you can bring the change in these two persons. Those who are they are in. I mean, though they are married, they are in quarreling and they are in not good terms. You can change that.
Yes, yes.
Only. The petitioner before this court is the wife in the marriage. Had learned counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of the CP number. Says MAT CP number. MAT, all capital. MAT space CP number 82 of 2026. Pending before the learned judge, Family Court, Noyagada, to the learned judge, Family Court, Rourkela. Stop. The CP has been filed by the wife, the husband in the marriage under section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. Para. It is submitted that the petitioner, after her marriage has run into rough weather, stays with her parents at Raurkela. She finds it difficult to attend the matter at Noyagarh. Para. So notice to the opposite party along with this out ଜିନିଷ ଲେଖିବେ ତା ଦେହରେ ଗୋଟେ ପାରା add କରି ତାପରେ ଲେଖିବେ. The learned counsel for the petitioner also refers to the petition filed by the wife in the marriage under section 144 of the BNSS, that is CRLP number 57 of 2026 under section 144 of BNSS, seeking monthly maintenance pending before the learned judge family court Raurkela. They submitted that as the petitioner is not maintained by her husband, opposite party, she had to file the application under section 144 BNSS. Tapar lekhibe issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to
10/8.
The matters shall be listed for orders in the week commencing 17/8/2026. IA 194 of 2026. Hard learned counsel for the petitioner. He reiterates submissions as noted above. Stop. Issue notice as above, accept one set of process fee as well as postal requisites. Returnable date as well as the next date of proceedings shall be as directed above. In the interim, it is directed that CP number 82 of 2026 pending before the learned judge family court Noyagarh shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter. Yes. Upon a prayer being made for the state purpose. You have to appear and seek for adjournment. Yes.
11.
So Devasis Samal for the petitioner.
My wife seeks a transfer of the CP case from Bhubaneswar back to Hyderabad.
Bhubaneswar to Bhadrak.
My love, she has filed a maintenance case in family judge.
How many other cases he has filed against the husband? How many other cases he has filed against the husband? 498A?
498A.
Where it has been filed?
That in Bhubaneswar. Just living permanent resident of the husband at Bhubaneswar. Then she led away and took shelter at a parental order.
Take notice, had learned counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of the CP number 255 of 2026 pending before the learned judge family court Khurda at Bhubaneswar. 1, 2 kichi nahi.
Notice were being served in this matter. No one.
Pending before the learned judge family court Khurda at Bhubaneswar. 2 to the court of learned judge family court Bhadrak. We submitted that the petitioner, after her marriage has gone into rough weather, has been staying with her parents at Bhadrak. She is deprived of any maintenance and has filed application under section 144 of BNSS, that is CRP case number 92 of 2026, pending before the learned judge family court Bhadrak. Stop. The submitted, she has also filed application under section 12 of the Domestic Violence Prevention of Purada Likhive, which is pending before the Lord Judge Family Court, Lord SDJM, Bhadrak. Stop. They submitted the petitioner finds it difficult to attend the matter at Bhubaneswar. And accordingly seeks transfer. Stop. Para issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery.
Two sets up and two orders. Yes. Two sets of notice in two orders as well at Bhubaneswar.
You want to take at both? Okay. So notice to the opposite party by speed post and with registration and proof of delivery. Requisites for issuance of notice shall be filed within 5 working days. Within 3 working days, it is submitted by the Lord Counsel for the petitioner that a petitioner shall take notice in both the addresses, both the given addresses of the petitioner. Accordingly, the notice shall be issued in both the addresses. Returnable date be fixed to 10 the matter shall be listed for orders in the week commencing 17 IA 183 of 2026. Hard Lord Counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee. Issue notice as above in both the addresses. Both the given addresses of the opposite party. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. Stop. In the interim, it is directed that the CP number 255 of 2026, pending before the learned judge family judge Khurda at Bhubaneswar, shall be Bhubaneswar alga na Khurda at Bhubaneswar. More कहवाटा भूलेला.
District Khurda, but family judge 1, 2, 3 that is Bhubaneswar.
Somebody कर दियो तो family judge Bhubaneswar. Khurda काट देगा. Family judge Bhubaneswar shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter.
Item 12.
Petitioner your wife seeks to transfer the CP number 33 of 26 pending the London Judge Family Court Baripada Mayurbhanj to the London Judge Family Court Baleswar Mailar. CCP was filed by the husband.
Take notice. Petitioner before this court is the wife in the marriage. She seeks transfer of the CP number 33 of 2026. Pending before the Lord Judge Family Court Baripada to Lord at Baripada at Mayurbhanj to the Court of Family Judge at Baleswar. Grounds, sir?
Grounds merit, the petitioner already filed one for proceeding merit sentence, that is CRP number 160 of 25. That is pending, my lord. The petitioner and one DV miss case 163 of 25, my lord. In both the cases, the husband was appeared, my lord.
But upon a Joleswar address, Gayatri Dasta. They submitted that the petitioner after her marriage has gone into rough weather stays at stays with her parents.
Not my lord, brother-in-law.
Stays with her relatives at Baleswar.
Joleswar at Baleswar.
Joleswar in the district of Baleswar, but Joleswar is nearer to Baripada actually. Anyway, Jaleshwar in the district of Balasore. C is not maintained, C doesn't receive any maintenance and accordingly has filed application under section 144 of the BNSS seeking monthly maintenance which is pending before the learned family judge Balasore. How can case file question?
One DV miss case 163 of 25.
He has also filed domestic application under
section 12.
so and so Domestic Violence Act. That is DV miss case number
163 of 25.
163 of 2025 pending before the
Learned JMFC Jaleshwar.
Learned JMFC Jaleshwar. But sir, Jaleshwar Balasore to alga jaga hai gala.
That is the
Jaleshwar ta kati diyo. She has also filed the domestic violence kato. But issue notice along with this order. So notice the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to 10/8/2026. The matter shall be listed for orders in the week commencing 17/8/2026. Then IE had granted counsel for the petitioner. He reiterated his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed. The CP number 33 of 2026 pending before the learned judge family court Baripada, Murpur shall be adjourned beyond a date. Adjourned to a date beyond 24/8/17/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the state purpose. Yes, next.
13.
The petitioner is the wife.
Yes.
She filed a maintenance case before the judge family court Kendrapada and a criminal case which is pending at Kendrapada. Her husband had filed a divorce proceeding in the court of judge family court Baleshwar.
One from Baleshwar to Kendrapada. Take notice. So Manoj Kumar Mahanti for the petitioner. Opposite party blank. Hard granted counsel for the petitioner. The petitioner before this court is the wife in the marriage. She seeks transfer of CP number 785 of 2025 pending before the learned judge family court Balasore to the court of learned judge family court Kendrapada. The CP has been filed by the husband in the marriage under section 13(1) of the Hindu Marriage Act seeking resolution of marriage solemnized between the parties on 6/2/2022 and grant of decree of divorce. It is submitted that that the petitioner, after her marriage has gone into rough weather, stays with her parents at Kendrapada. Parents in the district of Kendrapada.
After Rajkanika.
She has filed application seeking maintenance, monthly maintenance under section 144 of the BNSS as she is not being maintained by the opposite party husband. Pending before the learned judge family court, Kendrapada. Issue notice the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days.
Yes, ma'am.
Returnable date be fixed to 10/8/2026. Matter shall be listed for orders in the week commencing 17/8/2026. Stop. IA. Hard learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that the CP number so and so pending before so and so shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter.
It was fixed yesterday, my lord. Due to paucity of fund, I could not go and appear in that.
upon a prayer being made for the state purpose. So I'm not specifying the date. If already the date is gone, then no difficulty because it has to be adjourned.
15.
Your Lordship, on behalf of Mr. Mahanti, kindly adjourn the matter to next week.
Your name, sir?
Badri Vishal Priyadarsan.
Badri Bhushan Priyadarsan.
Badri Vishal Priyadarsan.
Mr. Badri Bisal Priyadarsan on behalf of Aurobindo Mahanti for the petitioner. Adjournment is sought for on behalf of the Learned Counsel for the petitioner due to personal difficulty. The matter shall be listed for fresh admission in the week commencing. 27.
Obliged.
16.
The Sanjay Kumar asked for the petitioner.
My lord. In this case, my lord, the present petitioners pray for challenging the demand notice issued by the SA authority, my lord, which is not applicable for the institution, my lord. My lord.
Have you sought copy on Mr.?
Yes, my lord.
Any instruction, Mr. Tripathi?
Case number 2-3, not permissible period 6/12 to 11/14, and the order was passed on 19/27/2017. And approach the appropriate government.
Yes, High Court.
High Court on 1675.
But that period, I'll condone. I'll direct condonation.
Has to be there.
Case representative देबे मोर जोड़ा का डिस्पोज ऑफ कॉलोनी ये सेरा ऑर्डर उड़ा कड़म कोर्ट है ये सेरा ऑर्डर इज डिस्पोज ऑफ फीच so das can you wait can we pass it over?
Yes.
Pass over it.
Yes, ma'am.
Just next.
Yes, ma'am.
Mr. Tripathi's submission is that already these matters have been dealt with by this court. Though there is a limitation, but I am directing condonation of delay and it goes to the ESI court. That is the district judge. ESI court is now defined as district judge. Just give us a moment. Okay.
Yes.
Yes. Next.
17.
Yeah.
Mr. S. Swami for the petitioner.
Yes. Mr. Nilamadhav Bisoi.
I'm sorry, Mr. Nilamadhav Bisoi for the petitioner. Yes, Mr. Bisoi.
Yes, my lord. Lord, I am a legal aid impaneled counsel. I have been assigned this matter to file this writ petition before this honorable court, my lord. Lord, fact of the case is, Lord, the petitioner is the wife, the widow of the deceased victim who has been murdered by virtue of the crime, my lord. And Lord, Lord, I am coming to the date, my lord. I filed on 26/1/2015. One Subedar Khan, husband of the.
Don't narrate the facts.
Yes, my
You
lord.
have to argue the law.
Yes, my lord.
So,
My lord,
yes,
my lord.
In a murder case, what the
Lord, the accused has been acquitted, and by virtue of benefit of doubt.
whatever.
Yes, my lord. And irrespective of the result of the ST case, my lord.
Is there
the
any presumption of culpability in our?
No, my lord. No.
So he's innocent. He continues to be innocent.
Yes, my lord. And victim is ignorant of the law.
The court is looking for evidence.
Yes, my lord.
Court is not looking for perception.
Yes,
please appreciate that.
No, only thing is
Anyway,
that the victim.
What is the case here?
My lord, the petitioner is entitled to get the compensation by virtue of
Under which provision?
Under CRPC 350. The original provision of law is the section 357A of the CRPC, my lord.
When this matter was taken up by whom? Who is 357? Anyway, let us go to 357. Bhai understand na?
Yes. And permitted to read, my lord.
Definitely, sir.
Yes, my lord.
But I have to also to get that.
Yes,
57?
357 capital A, my lord.
नहीं पूरा ना पढ़े हो तो.
Yes, my lord. The Subsection 1, my lord, every state government in coordination with the central government.
For batch code. CRPC रे आपण पढुचंती 357.
357 is CRPC, my lord.
ମୁଁ ବି ତ ପଢୁଛି.
Yes, 357A, capital A.
ନାଇଁ ପୁରାଟା ମୂଳରୁ ପଢିବେ. ସେକ୍ସନ ଟା ମଝିରୁ କେ ପଢନ୍ତୁ.
Yes, that is the heading is the victim compensation scheme, my lord. Capital A.
Criminal procedure code. ଆପଣ 357 ଟା 357 ଆଗ ପଢନ୍ତୁ ତାପରେ ଏ ପଢିବେ.
My lord. That is order to pay compensation, my lord.
Yes.
Yes. Subsection 1, when a court imposes a sentence of fine or a sentence, including a sentence of death, of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied. Clause A, my lord, small a, in defraying the expenses properly incurred in the prosecution. Clause B, my lord, in the payment to any person of compensation for any loss or injury caused by the offense, when compensation is, in the opinion of the court, recoverable by such
So
person.
357 is not applicable in your case.
No, no. No.
So then
So that is a
357A.
357A that
Capital A.
Yes, my lord. That has been inserted by Act 5 of 2009. My lord. Yes, my lord. This is subsection 1, my lord. Every state government in coordination with the central.
ସବୁବେଳେ ଆରମ୍ଭ ଅଭ୍ୟାସ କରନ୍ତୁ ପଢିବେ ସେଣ୍ଟେନ୍ସ ଟା with section with the heading.
Yes, my lord. This is a victim compensation scheme, my lord. The subsection 1 is every state government in coordination with the central government shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation.
ଏବେ ଗୋଟେ ସବୁ ମିଷ୍ଟର ରାଉତ ଆର୍ଗ୍ୟୁ କରୁଥିଲେ ଏବେ ନୂଆଟା ଏବେ ଆଉ ଗୋଟେ yes
Yes, my lord. Then my lord, subsection 2 is whenever a recommendation is made by the court for compensation, the district legal service authority or the state legal service authority, as the case may be, shall decide the quantum of compensation to be awarded under the scheme referred to in subsection 1.
So the recommendation?
Yes, my lord. That is, my lord, here the application of the petition has been rejected by the district legal service authority.
Recommendation. Section ଟା ପଢନ୍ତୁ author.
Yes, my lord.
Whenever a recommendation is made by the court.
By the court. There is no recommendation at all. It has not been taken into consideration in the judgment, in the ST trial case, my lord.
You are confused.
No, my lord. There is no recommendation with reference to the victim compensation.
Read again 357.
Yes, my lord. Where
357 फिर ये पढ़िले 357 पढ़ନ୍ତୁ.
Order to pay compensation. When a court imposes a sentence of fine or a sentence including sentence of death, of which fine forms a part, the court may, when passing judgment, order the whole or any part of the fine recovered to be applied.
पढ़ନ୍ତୁ.
In defraying the expenses properly incurred in the prosecution, in the payment to any person of compensation for any loss or injury caused by the offense, when compensation is, in the opinion of the court, recoverable by such person in a civil court. Similar, when any person is convicted of any offense for having.
So now kindly again go to 357 capital A 2.
Yeah. So whenever a recommendation is made by the court.
So this is which recommendation to be made by a court?
Regarding compensation.
Correct.
Yes.
Where it can be made? Where is the recommendation in your case?
There is no recommendation, my humble.
Then how it can be granted?
Yes, my lord. This is
because you see, if your is then what is your argument actually? It is a case of acquittal.
Yes, my lord. Irrespective of
so there cannot be any recommendation if you go by 357.
Yes, my lord.
In case of acquittal, the court cannot recommend.
No, irrespective of the result of the sessions trial case in the murder, irrespective of the result, compensation is.
It is not a debate competition. I can speak. So then why I am reading?
Yes.
What you are saying, where you are reading that? Irrespective of trial, where you are reading those words?
There are some judgments of the Hon'Ble Apex Court also.
Sir, first you go to the section, then you go to Apex Court.
Yes, my lord. Yeah.
which section you are referring, irrespective of the
I'm
conclusion of trial or irrespective of acquittal or
No,
conviction?
this is with reference to the judgment, my lord. This
Which
is
judge?
this honorable High Court and the Honorable Supreme Court, but the
Sir,
High Court
which
judgment is
judgment you are referring that in case of acquittal also compensation?
her compensation is there.
Then why you are placing 357A?
Because by
You
virtue
are
of,
placing 357A.
yes, my lord.
So in 357A, there is a concept of recommendation. Or you are unable to follow.
Yes, my lord.
So where is that recommendation?
That is no recommendation at all.
Then why you are relying on 357A?
Because by virtue of this application, only on this, by virtue of this section,
By virtue of which application you are saying? Is it a ex gratia payment by like a revenue?
No.
It has to be bound. It is bound by criminal court.
No, any.
Or what is the corresponding section in BNSS?
396.
396.
Yes, madam.
There is no amendment.
No.
So now if you are relying on 357A, you have to show the recommendation.
The recommendation, there is nothing because this is.
What do you mean by nothing?
No, my lord.
Then why you are arguing?
No, my lord.
Sir, either you stand by law or you fall by it.
No,
So
my humble submission is that.
Sir, am I not humble? Is the question is very humble? There can't be any more humble question than this. Which is the provision of law you are relying on?
Not 357A.
So where is that?
Because
So I am asking you, where is the recommendation?
No, my lord, there is no
Then
recommendation.
why you are relying on 357A to fail in the matter?
No, because
If you are relying on 357A,
by virtue of this section, my lord, the impugned order has been reflected. This provision of law.
sir, are you speaking law or teaching common sense?
No, my lord, I
So
am.
350. If you are relying on 357A to argue your matter in High Court, being a legal aid impaneled counsel, so where is the recommendation?
There is no recommendation.
Then why you are arguing on 357A? You have to do some research.
Impugned order, my lord, that
There is
reference of 357.
The impugned order is against you or you are in your favor, you have challenged it?
Against me.
So you are challenging that order?
Yes, my lord.
So you have to show a provision which helps you.
Yes.
Or you will show a provision that which will not help you.
No, my lord, because
it-
I cannot
Arre,
go.
why you are
I
laughing?
cannot,
I
my
don't
lord, I
understand.
cannot go beyond 357A, my lord.
You did not go. Who is asking
Yes.
you to go? You are arguing to win the case or lose the case?
No, to win the case.
Win the case?
Yes, my lord.
So you are relying on a provision to seek compensation.
Yes, my lord.
So that provision is completely against you. So have you
I
thought
have
of that or you will discuss
No,
it in your spare
no,
time?
my lord. I have relied upon this 357A1, subsection 1.
Sir, have you read or you are just
No, I have come across.
So how does one help you?
Because the state government has prepared a scheme.
So who says that state government has not prepared any scheme?
No, only on the basis, my lord, that delay has been taken into consideration that within 12 months from the date of the crime, the victim compensation application should be submitted for the legal aid authority, my lord. And the petitioner, by virtue of ignorance of
Sir,
law,
all
has
this
filed.
speech you are giving, can you not refer to any provision in CRPC? The delay 12 months?
No,
Don't make an extensive speech.
No, yes, my lord, I'm
So
coming to
kindly
this.
straight away go to the section.
I am coming to this. This is by virtue of this 357. 1 minute, the state government has prepared a scheme, that is Orissa Victim Compensation Scheme 2017.
সেটা বাহার করে পড়ো।
This minute.
আমার কাছে এক্সট্রা কপি আছে?
Yes.
ঠিক আছে।
The definition of victim is also under section this scheme 2 small g, my lord. First page, last clause, my lord. Page 6, my lord, clause 10, the limitation is there.
পুরোটা পড়িয়ে পড়বে আপনি সেটা পড়ছেন?
Yes, the relevant person.
I have difficulty not reading.
Yes,
I have to read.
Yes.
इतने victim define ହେଇଛନ୍ତି କୋଉ section ରେ?
Milord, beg your pardon.
Victim କୋଉ section ରେ define ହେଇଛନ୍ତି?
This is section 2G, clause 2G, small g, Milord, at the first page. The victim means a person who himself or herself suffered loss or injury as a result of crime and requires rehabilitation, and in case of his or her death, also his or her dependents.
Come to the
And also section
come to the provision limitation.
limitation, this is 12 months. This is clause 10 of this scheme.
So any case law on this, High Court can condone or Supreme Court has condoned?
No,
So do that, sir.
Yes.
Some research. It's an absolute bar.
Yes. No. But the thing,
A suit, Mr. Bisoi.
Yes.
Can it be filed with a limitation application?
No.
Can cognizance be taken with a limitation application?
No.
So that's the law.
Here the only
So
my information is that
at least
the
you instead of making only submissions,
uneducated person, Milord, without ignorance of law, Milord.
sir, uneducated person's suit is maintainable with an application for limitation.
Suit is not.
Then you must talk law, sir. Apart from being sympathy, education does the bar, absolute bar as far as suit or cognizance is concerned? Is there any, case law on this, that if the person is uneducated, then it is entertained?
No, Milord.
Does the Limitation Act contemplate any such provision?
So this is the facts of the case, Milord.
No,
Indigent
sir,
person.
sir, please argue.
Yes, Milord.
Sir, please argue law. That would help the petitioner
Yes.
who already maybe is in distress.
No.
But when the law makes no exception, how you can make or I can make? Obviously, if a law has been laid down by the apex court, fine.
But here,
The
Milord,
counsel for the petitioner was heard at length.
Milord, another may be permitted. So, Milord, in the 357A4 also.
Sir, let us not waste time, sir. We are now, you are
This is the ground. Because
accordingly.
How it is not
You have
applicable.
to-
That limitation, how it is not applicable. Because here
You are not reading. Read the provision of limitation. Problem is that you are speaking a lot, not reading.
that limitation I cannot.
What is the starting point of limitation?
This is no claim made by the victim or his dependent.
সেটা তো পরিচয় সেটা কহিবে পড়িলেন পড়ুন
Yes, Milord.
Yes, no claim.
No claim made by the victim or his dependents under subsection 4 of section 357A of the code shall be entertained after a period of 12 months from the date of crime.
So one word upon answer the date of crime. When I ask you what is the starting point of limitation, date of crime.
Yes.
So starting point is date of crime.
Yes.
So what you are saying now, that limitation is not applicable? Why you are saying?
Why I am saying? Because it has been referred subsection 4 of section 357A, Milord. Your Lordship may kindly come to
Section 4
of section 357A of CRPC, Milord. Milord, I am reading.
তাকে ভুলিয়ে
No, I am reading it again.
357A is applicable to you.
Milord, that is the law, Milord.
ଏ ତ ସବୁ ପୁରା ପଢିଥିବେ, that is the law, ଖାଲି କହିବେ ଏଟା କଣ ଇଏ debate competition. 357 ଆପଣ ପା ନିଜେ ଦେଖିଲେ not applicable to you. What is 357 ଆଉ ଥରେ ପଢନ୍ତୁ? Sir, we are wasting precious time of your time and my time. ଆପଣଙ୍କର lack of preparation should not reflect on our time. 357 ପଢନ୍ତୁ. 357 applicable ନୁହଁ ବୋଲି ଆପଣ victim compensation scheme କୁ ଗଲେ. ତାପରେ again you are back to square one. ପଢନ୍ତୁ 357.
I do understand, Milord. Because there is no recommendation. I do understand, Milord.
You did not understand anything, like I am not understanding anything. I am simply reading.
Because whatever the law speaks, Milord, whatever the law speaks in the scheme under, that is what I am reading.
ଭାଷଣ ଦଉଛନ୍ତି, don't do that. Do the basic of a lawyer, that you read 357A.
Again, I'll read.
This is somehow not working, Mr. Bisway, not expected from you also. Preparation ଦେଖନ୍ତୁ ପଢନ୍ତୁ
Lord, victim.
କୋଉଟା ଆପଣଙ୍କ ପାଇଁ applicable ହବ?
This is, I rely upon 357(1) is relevant and applicable to the petition, I mean, not 4. 4, there is a limitation. And that limitation in the original code, there is no such prescribed limitation.
Why you are going on speaking, sir? Which part of the 357(1)
Yes.
enables ପଢିବେ ସିଧା?
Lord, every state government in coordination with the central government shall prepare a scheme for providing funds for the purpose of compensation to the victim or his dependents who have suffered loss or injury as a result of the crime and who require rehabilitation. This is relevant.
So then who is saying that it is not relevant?
So here, there is no prescribed limitation.
So how do you say that this victim compensation scheme is not applicable to you? Then on what basis you will get?
Yes, Minor. But whenever the 4 is there,
yes, my lord,
subsection 4 is there. 4, I am reading it, Minor. Where the offender is not traced or identified, but the victim is identified. But here the
4 of what?
357(a), subsection 4.
ଆପଣ ସେତେବେଳେ କହିଲେ 357 ବର୍ତ୍ତମାନ A କହିଲେଣି.
No, 357 capital
357(a) ରେ ଆପଣ problem ହଉଛି you are not reading, you are missing the words. What was your answer when I asked you that where is the recommendation? What is your answer?
Recommendation is subsection 2.
Yes. So what was your answer when I asked you that if you are relying on 357(a), where is the recommendation? What was your answer?
Answer is no, Minor.
So rely କରୁଛନ୍ତି. So then I asked you that if you are arguing a case, we want to win or you want to lose the case. Then you went to the victim compensation
I cannot go beyond 357(a), Minor.
So whether you go beyond that, that's not important. Don't make your rhetorics. Empty rhetoric doesn't help in arguing a matter. It is a serious, we are in a very serious legal discussion.
Yes.
No, I
am not doing
anything like that.
Yes, the 4 is there when the offender is not traced or identified, but the victim is identified. And when no trial takes place, the victim or his dependents may make an application to the state or the district legal service authority for award of compensation. But in my case,
is it applicable to you?
It is not applicable. That is what my submission is.
Why you are going to 357(4)?
Because that is there in the impugned order, Mira.
You are ବୁଝେଇ ହବନି. ଅଲଗା 4ଟା ପରେ separate argument hearing କରିବାକୁ ପଡିବ. Sir, whenever you are relying on this victim compensation scheme, ଆପଣ ଆଉଥରେ ପଢନ୍ତୁ ଯୋଉଟା ଆପଣଙ୍କର ଆଉଥରେ ସେ logic ଆମେ ଦେଖିବା. But at least right now I am hearing as if I am hearing you as a victim who is seeking compensation. Even I am not looking at what the reasoning is given. So you must try to give the provision where you can be awarded. That is your effort. Now we can go to the limitation.
Yes.
What you have placed. It is absolute bar.
Yes, Minor.
So then you have to examine which you have not done, or you may do. Nobody is reading.
Yes, Minor.
No difficulty if you are not reading, but you please examine if there is any case law. If suppose the court has said that there is a limitation runs because it starts on which day? Date of crime.
From the date of crime.
So date of crime. Suppose now the court has held that from the date of crime beyond 1 year the application has been made.
Yes.
Correct. Now there can be a case law developed or the Supreme Court or any High Court has dealt with that. First you have to look at that. And now the problem is 357(a)(4) definitely is against you. The court has held that.
But that, considering the facts of the case, it is not relevant, not applicable to me. My humble submission is this.
Apart from the humble state law, kindly place that part of the judgment. Making humble submission is not important.
Yes, Madam.
Which part is not applicable?
Because.
Place that.
Lords, may kindly come to page number 18, Madam.
18.
18. 19 in the last part.
Last para kintu?
Yes, ma'am.
Pura context re padhibe na?
Yes, ma'am. May I read the last para?
About you obvious karna the so all for padhiba. Judgment padhibe, read the context.
This
If
appeal
you
under
do not,
clause.
stay, आप पेज 18 को जानते हो?
Yes, my lord. This appeal under clause
सेटा
11
छाड़
of
दियो,
the.
सेटा दरकार नहीं.
My lord.
Original order टा क्या है? 31/24 order टा पढ़ो तो.
That order has not been supplied to me.
Who will supply? Court will supply.
No, legal.
You should have asked the legal services authority. You are not even half prepared. You are only reading the appellate order, original order. Then I should not have spent time with you. How could I know that you have not read even the original order? Kindly mark the intensity and the depth we are going.
Only aspect is
Thanks
the
to you
limitation is there.
At least you have
That has
studied
been-
something. But if you do not read the original order, then how will you understand?
My lord, only point is there, the limit, barred by limitation. The
Sir, I'll
district-
record that. I will record that. I will say that you have not read the, you do not have the.
No, my lord,
So it is submitted by.
No, my lord, I'll request to get that. I'll request.
Legal aid
No,
counsel that the only point to be determined.
No, my lord. My lord, I'll ask.
No, my lord. Fair record.
Sorry, my lord, sorry.
I am really sorry, Mr. Bisoi.
Okay.
After half an hour, when I ask you that read the original order, I in fact, I was not aware. Like you have never been provided. Mr. ଆପଣ ଯେମିତି ଜାଣିପାରୁଛନ୍ତି ଆପଲେଟ୍ ଅର୍ଡର ପଢିକି ମୋର ଜାଣିବାର କ୍ୟାପାସିଟି ନାହିଁ ସେଟା ବି ଆପଣ ଯଦି କଣ ଆଜ୍ଞା ଜାଣିପାରୁନାହାନ୍ତି କଣ ମୋର ନାହିଁ କ୍ୟାପାସିଟି I have to see the original order then I can understand
I'm sorry.
what is the context if at all if you are thinking like that. Mr. Nilamadhava Bisoi for the petitioner. Mr. Ansuman Sethi for the OP number opposite parties. The learned counsel for the petitioner has been engaged by the Odisha State OSLS or High Court.
Odisha State Legal Service Authority.
Odisha or High Court?
No, Odisha State Legal Service Authority.
अरे नो दीटा जाक अछि नो कहले केमती होबा ओडिशा ना हाई कोर्ट की आपण एंगेज करछन
इन ओडिशा
देखिले कोर्ट सेडा अछि कना केस त हाई कोर्ट रे
the present writ I have filed before the High Court, but here I have made the part.
अच्छा आपण ब्रीफ देला पर आपण हाई कोर्ट रे अपील फाइल कले रिट पिटिशन
Read file. This writ I have
कौन लिखले states that he has been engaged by the Odisha State Legal Services Authority.
OP number 2.
आपको क्या opposite party कर दिले to appear to file the case and accordingly he has filed the case. Now that counsel has done a lot of labor in arguing the matter for more than half an hour. He has touched several aspects of the provisions contained in the CRPC, section 357, 357A, 357 into bracket लिखिए, since repealed and substituted by perimeter provision. Section 395 in BNSS 20,2023 bracket closed. 357A. To bracket section 396 of BNSS as well as the Odisha Victim Compensation Scheme, 2017, notified by the state of Odisha on 31/3/2017. The challenge in the writ application is to the order dated 8/8/2025, passed in Victim Compensation Appeal number 11 of 2024 by the appeal to advocate general ko pakhre.
Yeah.
Appellate authority ki advocate general.
Appellate authority, state legal service authority.
To dekhile page 19.
Yes, madam. Principal Secretary to Government, Law Department, Odisha, and Advocate General, Odisha.
They are the authority.
They are the
By the appellate authority.
appellate authority.
Into bracket annexure 1 to the application. And so to the petition. Or be asked to submitted by the learned counsel for the not a legal aid counsel that he has not been provided with a copy of the order dated 31/8/2024 passed by the learned District Legal Services Authority, Nuapada, in with VCA number 03 of 2024. Para. It is submitted that during hearing of the matter, the learned counsel was requested to place the order passed by the learned DLSA Nuapada in VCN 3 of 2024. He expresses helplessness as he has not been provided. The OSLSA करचंती.
Yes.
Seat दरकार है फिर. The learned secretary OSLSA shall provide the entire records of the copy of the entire records of the VCA number 03 of 2024, which was disposed of by order dated 31/8/2024. The learned legal aid counsel is requested to approach the secretary OSLSA.
Yeah.
The copy of the scanned copy of the records of the victim compensation appeal number 11 of 2024 and VCA number 03 of 2024 shall be obtained by the registry to be kept for reference. ଆପଣଙ୍କର ବେସିକ 1 ପଏଣ୍ଟ ରେ କୋନ 1 ସେଣ୍ଟେନ୍ସ ରେ କୋନ କେସ୍ ଟା ଚାହୁଛନ୍ତି को आर्ग्यू करिया पे
The delay to be condoned.
सेटा आपनको डेवलप करे पड़े पर्यंत सूट रे तो डिले हेनी सूट रे हेनी कॉग्निजेंस रे हेनी
And
कोथ रे
such
हेनी
for the judgment.
सेटा हेई परिबो
Such for the judgment. The ignorance of the law, my lord, the lady or
Ignorance.
widow having two male
कोन
children.
इग्नोरेंस ऑफ लॉ पढिथिले लॉ स्कूल रे इग्नोरेंस ऑफ लॉ पढिछथि कोन मैक्सिम टा कोन मु जा पढिछि लॉ स्कूल रे इग्नोरेंसिया जुरिस नॉन एक्सक्यूजेट कैनॉट बी एक्सक्यूज्ड ଆପଣ
The status of the petitioner uneducated, rustic,
ଆପଣ इवन लिमिटेशन एक्ट रे प्रोविजन नै
yes, my lord, rustic villager, uneducated lady.
ଯଦି ଆପଣ ସେକ୍शन 5 आर्ग्यू करछन्ती आपण कंफ्यूज हे गेलेनी आपण कोन आर्ग्यू करछन्ती सेक्शन 5 जो सॉरी जो एप्लीकेशन फाइल होची सेथिरे आपणकर रस्टिक विलेजर पर्दानासी लेडी
Yes. Not been rehabilitated, not been rehabilitated, it should be considered. Solution.
कहीं सूट रे कहीं सेटा नहीं उन आंसर करि पर ना तो दैट यू हैव टू थिंक आपण एक्सपेंसिव प्रोपोजिशन जेतले देबे यू हैव टू बी सॉलिड बट ऑब्वियसली यू हैव डन सब्सटेंशियल वर्क आपण बहुत तक भाबी चंती बट ए पॉइंट रे आई थिंक देयर इज नो एस्केप कारण आपणकर when there is scheme is formulated itself it has a limitation how the court will expand it
But the original
that is how CPC that is how CPC has never been
original CRPC, there is no limitation. In the state scheme, there is a limitation.
there has to be
There is no limitation in the CRPC.
आपण पैसा दउचंती की
You know?
पैसा आपण दउचंती की
No, no.
taxpayers money आगे
Ah, yes.
at times we are a charity without liability
No, no, no.
I will not pay 1 rupee but when his money is paid Mr. Panda or Mr. Ansuman, Mr. Naik's money
This
and
is not coming to my pocket.
No. You are not paying from your pocket.
Yes.
That is how the responsibility. When the legislature
No,
thinks that
it is also not coming to
taxpayers'
my
money,
pocket. Miller.
taxpayers' money should
I
be
am
spent
pleading
the way.
as a legal aid counsel.
No,
for
that is another thing.
For the welfare of the
You may
petitioner.
not do legal aid cases.
Yes.
You do not do.
Yes.
Because you are not happy with the fee, somebody else will do. That's where not discussed.
No, I am not.
But because you asked that rustic villager, he should get the money, but the legislature is paying the money, and who is paying? He thinks that, they think that, and limitation can be imposed. Upon a victim compensation, arrow side flip side of victim compensation.
No.
You are innocent, as you have been always. Knowing you, my impression that you are too innocent in so many cases, you will find that victim compensation is misutilized. It is beyond imagination and surprising also. Yes.
Petitioner being the victim also has not been rehabilitated.
Let us see. Kouthere paibe seta important. When there is a statutory scheme, the statutory scheme is specific. Next, password attack. Next date, Mr. Bisoi se jo record asibo. Yeah. Se record asila pore ja hobo.
Your lordship is not after 1 month.
The matter shall be listed for order test for fresh
admission.
Fresh admission in the week commencing 10 years.
Okay.
Copy of this order shall be forwarded by the registry to the Honorable Secretary DLSA. No, OSLSA. OSLSA. Again, pass over it. Mr. Tripathi kode gale?
Yes, Raj.
Mr. Tripathi. Yes, next.
18.
Mr. Ansuman, you also go through the provisions.
Yes, Your Lordship.
Please, Your Lordship.
At least Legal Aid Council is doing so much of effort. You have the chance to go through that. Like at the 18. Mr. Abhay Kumar Parda for the petitioner. Yes, Mr. Parda.
My lord, here, my lord, the petitioner is the husband, my lord.
Yes.
The petitioner before the lordship is the husband.
Yes.
My lord, the opposite party, the wife, my lord. She filed a section 9 application for restitution of conjugal right. During pendency of that application, under Annex 2, she filed a 24 application for interim maintenance. That was allowed under Annex 3, my lord. 3,000 for wife and 3,000 for daughter. My sole
Mr. Parda, it is like this. We are spending a lot of time on these matters. You ask him to deposit whatever is due.
My lord, my sole point is, my lord.
No, sole point you will argue because now it is a decree of a court.
My lord, your lordship.
So after you know, just now order 41, Mr. Mohanty was arguing. I have cited order 41, 3A.
No, 11. My lord, he will paying the maintenance, my lord. My sole ground is the my lord.
Mr. Parda, if you are paying, then file that affidavit. If you are not paying, then how you will pay? You file that affidavit. That much.
Let me keep it some of the notice be issued, my lord, so that it can be.
I will answer that. I have already answered. That notice need not be issued.
My lord, may keep.
Have you read order 41?
No, my lord.
What is rule 10? What are you doing? CPC nahi apon. What go deri gochu. Ako 41 paile. 1-3 देखो तो.
Page 1.
Order 41, rule 1 into bracket 3. 77 amendment.
Order 41, rule 10, my lord.
1-3 आगे देखो. 3 ପାଉନାହାନ୍ତି
My lord,
ମୁଁ କଣ ପଢନ୍ତୁ
appellate court to give notice to court where decree
ଆପଣ ଆଉ ଗୋଟେ କଣ ପଢୁଛନ୍ତି
is
ଅର୍ଡର 41 ରୁଲ 1 then 3 ପାଇଲେ
is my lord to where the appeal is against a decree of payment of money, the appellant shall within such time as appellate court may allow deposit the amount disputed in the appeal or furnish such security in respect of thereof as court may think fit.
the 1977 amendment the 3A देखो 3 capital A
Capital A. Application for condonation of delay.
ତାକୁ ଛାଡି ଦିଅନ୍ତୁ ଆପଣ ବର୍ତ୍ତମାନ 10 କୁ ଆସନ୍ତୁ 10 ଅର୍ଡର 41 ରୁଲ 10
Yeah. It is. Appellate court may require appellant to furnish security of for cost.
ପଢିବେ ନା ମତେ
My
କଣ
lord, the
ହବ ପଢିକି ଆସିଲେ ଆପଣ କହୁଛୁ ପଢନ୍ତୁ
My lord. Sorry. The appellate court may, in its discretion, either before the respondent is called upon to appear.
stop there
My lord.
ଆପଣ କହୁଛନ୍ତି ଯେ ତାକୁ ଆପିଲ କରିବା ପାଇଁ କୁହନ୍ତୁ
My lord.
ତାପରେ ପଢନ୍ତୁ
And answer and afterwards on the application of the respondent demand from the appellant security for the cost of the appeal or of the original suit or of both.
now look at 11 just ତା ପରଟା
Power to dismiss appeal without sending notice to lower court.
Oh.
My lord, the appellate
court
court after fixing a day for hearing the appellant or his pleader or hearing him accordingly if he appears on that day may dismiss the appeal.
notice କଣ ଇସ୍ୟୁ କରିବା ପାଇଁ କହୁଛନ୍ତି other difficulty that sir even I am not appellate court I am a revisional court my hands are further tied even I can't evaluate the evidence another judgment of Supreme Court is C Lalita but I don't have collected and found out
Rajnesh versus Neha sethere aga affidavit of disclosure assessed liability ଦବା କଥା ଏଥିରେ ଆଜ୍ଞା ସେତେ ଦି
ସେଟା ଆପଣଙ୍କର କୋ ଷ୍ଟେଜ ରେ ଆର୍ଗ୍ୟୁ କରିବେ
ସେଟା
notice issue ହବ sufficient ହବ admit ହବ ତାପରେ ଆର୍ଗ୍ୟୁ କରିବେ ଆପଣ ଆଗ order 41 rule 1 3 ଆଉ 10 ଆଗ କ୍ରସ କରନ୍ତୁ
ଆଛୁ ଅଲଗା ଦିନ ମୁଁ ତାକୁ କହିବି
ନାଇଁ ଅଲଗା ଦିନ ଆଜି କଣ ସମୟ ନଷ୍ଟ ହବ ନା କଣ ଆଜି ଅର୍ଡର ହବ ସେ ଆପଣଙ୍କୁ ମାନିବେନି ଆପଣ ଯଦି ତାଙ୍କ କୋର୍ଟରେ କହିବେ ଆଜ୍ଞା କୋର୍ଟ ତ ଶୁଣୁନାହାନ୍ତି ସେ ଆପଣଙ୍କ କଥା ଆପଣ ଏମିତି ଝୁଲେଇକି ରଖିବେ ଆପଣଙ୍କୁ ମେଣ୍ଟେନାନ୍ସ ଫାଇଲ କରିବାକୁ ପଡିବ ବର୍ତ୍ତମାନ ବୁଝିପାରିଲେ କି ବର୍ତ୍ତମାନ ଲୟାରଙ୍କର ଯେ ସିଚୁଏସନ ହେଲାଣି କିଛି ଦିନ ପରେ ଲୟାରଙ୍କର ପିଟିସନ ଫାଇଲ ହବ ମେଣ୍ଟେନାନ୍ସ ଶୁଣିଲେ ତ ଫେର
ନା ଅଲଗା
ଦାସ ଦେଖିଲେ କିଛି ଅର୍ଡରଟା ତ୍ରିପାଠୀ ପଳେଇଲେ ଆଜି ମିଷ୍ଟର ରେ ବୋଧେ ନାହାନ୍ତି ତାକି ଦିଅନ୍ତୁ
ମୁଁ ଆଦେରେ ଗୋଟେ affidavit ଫାଇଲ କଲି ସେ କଣ ଦେଇଛି କଣ ନାହିଁ ଗୋଟେ affidavit
କରିବେ
ସେଟା ଗୋଟେ
but let us not waste time
ଡେଟ୍ ଗୋଟେ ହଉ
ଡେଟ୍ ତ ନିହାତି କାରଣ ଆଜି ନହେଲେ ଆଜି ଡିସମିସ୍ ହବ ନହେଲେ ଡେଟ୍ ହବ ଯଦି ଅର୍ଡର 41 ରୁଲ 11 ଆଜି ଡିସମିସ୍ ଆଫ୍ଟର ହିୟରିଂ ଦ ଲର୍ନେଡ୍ କାଉନସିଲ ମେ ଡିସମିସ୍ ଦ ଆପିଲ ତାପରେ ଆପଣଙ୍କର 3 ଟାକୁ ଯୋଉଟା 10 ରେ ଅଛି ଆଇଦର ବିଫୋର appearance or after so either otherwise Mr. Perida this becomes a fishing expedition today a matter after 5 years has been adjourned nothing
ନା ଏଟା
you see actually
ମୁଁ କାଇଁ I am praying ଗୋଟେ ଝିଅଟେ ଅଛି ତେଣୁ ତାଙ୍କ ଭିତରେ ସେଟଲମେଣ୍ଟ ହେଇଯିବ ସେଇଥିଲାଗି ତାଙ୍କର କାଲି
ଆଜ୍ଞା ମେଣ୍ଟେନ ନକଲେ ସେଟଲମେଣ୍ଟ କେମିତି ହବ
କାଲି ତାଙ୍କର ମିଡିଏସନ ଅଛି ତାଙ୍କର ସେଟା କାଲି ମିଡିଏସନ ପାଇଁ ଅଛି ଯୋଉଟା ମ୍ୟାଟ୍ କେସ୍
ମିଡିଏସନ ହବ 24 ରେ ହେଇ ପାରିବନି ଏଟା କଣ
24 ନୁହଁ ଆଜ୍ଞା ମ୍ୟାଟ୍ କେସ୍
you are a responsible lawyer you stick to law
ସେଇଥିପାଇଁ ମୁଁ କହୁଥିଲି
don't go by the version ଯୋଉଟା ଆସି ଆପଣଙ୍କୁ କ୍ଲାଏଣ୍ଟ କହିଲେ ଯୋଉଟା ଆସି କୋର୍ଟରେ କାଇଁ କହିବେ ଆପଣ ତାକୁ ଆପଣ ତ ଡିସ୍କରେଜ କରିବେନି ସେ ତ ପଳେଇବେ ଆପଣ ଶୁଣିବେ ଯେତିକି କହିବା କଥା କହିବେ
ଏଇଟା
ତାର କିଛି ରିଲିଭାନ୍ସ ନାହିଁ ଆପଣ 24 ରେ ପଇସା ଦେବେନି ସେ ହାଉ ଦେ ୱିଲ୍ ସର୍ଭାଇଭ ସେଟା କଥା ନୁହଁ
ନା ପଇସା ତ ଦବ ଆଜ୍ଞା ସେ ତ ଯୋଉଟା ଯେହେତୁ ଗୋଟେ ପିଅନଟେ ଅଛି ଘାସ କାଟୁଛି ମେସିନଟେ ସେ ପଇସା ଦବ କିନ୍ତୁ ମେନ୍ ହେଲା ସାର୍ ଏଟା କାଲି ମିଡିଏସନ ପାଇଁ ଅଛି ଯେହେତୁ ତାଙ୍କର ସେଟଲମେଣ୍ଟ ହେଇଗଲା ତେଣୁ ମୁଁ ସେଇଥିପାଇଁ କହୁଥିଲି ଗୋଟେ ଡିଫର କରନ୍ତୁ ଡେଟଟାକୁ
ଡିଫର ହବ ପରା କହିଲି ଥରେ
ଆଜ୍ଞା
ବଟ୍ ଆପଣଙ୍କ ଚଏସ ରେ ନୁହଁ
ନା ଆପଣଙ୍କ ଚଏସ
ମୋର ଅର୍ଡରଟା ମୁଁ ଏଠି ସମୟ ନଷ୍ଟ କରୁନି ବସିକି ତ 5 ମିନିଟ ହେଲା So heard on counsel for the petitioner at some length. The petition, take your seat, I'll just complete the order. The petitioner before this court is the husband in the marriage.
2016, my lord. My lord, I've dated
I
given
want to move. ନ ଡାକି ପାରିଲେ ବ୍ୟସ୍ତ ହଉଥିଲେ ଆପଣ ତ ଅଛନ୍ତି ଆଉ କଣ ଆପଣ ଅଛନ୍ତି ଡାକିବେ କଣ ବ୍ୟସ୍ତ କାହିଁ ମୁଁ ଡାକି ଭୁଲ ଭାଲ ହଉ ଡାକ ଆପଣ କୁହନ୍ତୁ ମତେ ସେ ପଳେଇଲା before by moving the petition writ petition he challenges the order dated the judgment dated 18/3/2026 passed by the learned judge family court Bargad in IA number 19 of 2025 arising out of MAT case number 132 of 2025 and 32 of 2025. Stop. The IA has been filed by the opposite party wife in the marriage under section 24 of Hindu Marriage Act, 1955, seeking maintenance pendente light during pendency of the MAT case number 132 of 2025. The MAT case has been filed by the wife. Upon a wife coach only to wife has been filed by the wife in the marriage under section. Take your seat. The MAT case has been filed by the wife in the marriage seeking restitution of conjugal rights under section 9 of the Hindu Marriage Act. During pendency of the MAT case, the application under section 24 has been filed. The learned counsel for the petitioner is apprised of the provisions contained in order 41. The Purada night. One 25 photo. ठीक है. Submitted तापर लिखिए 4-5-6 जो वाला. It is submitted by the learned counsel for the petitioner that the petitioner goes on paying the maintenance to the wife and child, one from the wedlock, who are living separately, as directed by the learned. सेटा जानचंती ना नहीं फिर लिखिले असुविधा हो कौन भाई आपण जो कहउचंती जे दउचंती बोली सेटा जानचंती ना नहीं
ना दौजन अजन जाननी
तो छाड़ दियो छाड़ सुन कोंतु कोन लिखले no ते काटी दे. The petitioner shall file affidavit indicating the amount paid as maintenance pendente light to the wife opposite party who stays with the minor child born from the wedlock. And or how to secure the amount as directed and remaining unpaid. The affidavit shall be filed. The affidavit shall be filed by
by the petitioner names.
2 weeks.
2 weeks.
Affidavit shall be filed by affidavit shall be filed by 22 the matter shall be listed. You want further time or what? Adhiya time chahuchonti. The affidavit shall be filed by 30/7/2026. The matter shall be listed in the week commencing 3/8/2026. Yes, next please. Upon what? Passo what केते जेडा
16
बोलो
अच्छा 16
से order टा हेले हिजिबो
आज्ञा सेटा खाली हमर इन द मीन टाइम से किसी कोर्सिव एक्शन न उचित मैंने
At the time of ଆମର କିଛି ସେତେବେଳେ ରୁଲ ନଥିଲା ଯେ ପ୍ରାଇଭେଟ ଇନଷ୍ଟିଚ୍ୟୁଟ ଦେବା ପାଇଁ।
ସେଟା ଆସିଲେ ଡିସ୍କସନ କରିବା ଅଛି ଆପଣ ଯଦି ରିସେସ ପରେ ରହିବେନି ଏ ଅର୍ଡରଟା କରିଦେଲେ ହବ
ହଁ
ନା ଆପଣ ଆସିବେ ରିସେସ ପରେ
ମୁଁ ଆସିବି
ଠିକ ଅଛି
ଦିସ୍ ଇଜ ଫାଷ୍ଟ
ମାନେ ଠିକ ଅଛି ପାସ୍ ଓଭର ମାନେ କଲ୍ ହବ ସିରିୟଲି କଲ୍ କରିବେ
ଆଜ୍ଞା
ଆଉ ତିନି ଚାରି ଏଇଟା ଟିକେ ରଖିଥାନ୍ତୁ ନେକ୍ସଟ
oblige
19.
May I please yours?
yes please
Subject to withdraw, my lord.
your name sir
And Lakshmi Nrsimha Sahu.
Mr. Lakshmi Nrsimha Sahu for the petitioner Mr. Anshuman Sethi for the opposite party ନାଇଁ ଏଇଟା withdraw ଯେମିତି କରିହବନି ଏଇଟା quasi criminal I have to reject this ଏଟା କପଲା ହେଇଯାଇଛି ଆରେ contempt ଟା ଥରେ withdraw ହେଲେ ସେଟା the jurisdiction is different
Yes, ma'am.
once withdraw means it is condoned ଆପଣ instruction ନିଅନ୍ତୁ ଖାଲି simply adjourn କରିଦିଅନ୍ତୁ କଥା ହୁଅନ୍ତୁ ସିନିୟରଙ୍କ ସାଙ୍ଗରେ
Sir, withdraw କରିବାକୁ ହେଲେ ମାନେ କିଛି ଡକ୍ୟୁମେଣ୍ଟ କମ୍ପ୍ଲାଏ କରିପାରୁନାହାନ୍ତି ତ ସେଇ ଏସଆର ଷ୍ଟାମ୍ପ ରିପୋର୍ଟିଂ ସେକ୍ସନ ସେଥିପାଇଁ ଏଟା ଲଜ୍
but it has to be dropped content petition ର fate ହଉଛି either the alleged contender will be punished after he is unable to show cause why the order has been violated
Yes.
possibly the contender will say that I have complied the order so show cause is accepted then it is dropped but if the allegation is withdrawn it has to be dropped
Yes, my lord.
so ठीक है by filing the application the petitioner alleges non-compliance of the order dated it is 7th December just a second Mr. Tripathi, since you are in other court, so just look at this order. Mr. Das is suggesting that no coercive action till he files.
Till next day.
So just go through this. And it will be disposed of.
Yes, ma'am.
Just kindly spend your time on that.
Yes,
I'm just dictating this.
I have read one through this decision.
Well, just give me a time. Give me a second so that I can complete this.
Yes, ma'am.
Give me a moment. Hold it. Order dated 7th December 2021, passed by this bench.
Yes.
Padagala order. Passed by this court in WPC number 320340 of 2021. Memo of date is filed by the Product Council for the petitioner, which states thus. Accordingly, the content application, the memo is taken on record. Scan copy be updated. The content petition is dropped. So you can carry out the necessary changes here. Please. Copy. Pencil le copy. এটা item কেতে এটা গলা Mr. Dasangara 16 disposed of. necessary changes କରିକି କୋର୍ଟ ମାଷ୍ଟର କୁ ଦେଇ ଦେବେ 16 ଉପରେ लिख देवे rest of the matters after recess anyone mentioning any matter 21 कौन कहउछन्ती सर ठीक अछि ऑर्डर पास करिया पड़े ऑर्डर्स में अछि
Recording in progress.
The matter was presented before this court on 5/9/2022. Defect is नहीं बोलते नहीं. Since then, it was not. Since then, it was never taken up till 29/6/2024 when it was listed for fresh admission and non-appealed for the petitioner. To grant further opportunity, the matter was directed to be listed today and accordingly is in the list for fresh admission. Non-appears for the petitioner, though the matter is called twice over, once when it reached and again after the resumption of the proceeding post lunch. Stop. The petitioner is also absent in repeated calls. ଆପଣ ଡାକିବା ଲୋକ ତ ନଥିବେ ଆଉ
ନା
ଭଲ. Para. Apparently, the petitioner has lost interest in prosecuting the matter and it is kept pending without any steps being taken for more than 3 years. For 3 years and 9 months. For about 3 years and 9 months. The petition is disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Henkana, to be kept in the records of CR.3. number 42 of 2020. Disposed of by judgment dated on 29/6/2025. Yes.
Password item 2.
Non-appears for the petitioner, though the matter is called twice over. Once when it reached and thereafter. Upon resumption of the proceedings of the court, post lunch, start. To grant further opportunity to the petitioner, the matter shall be listed for fresh admission on 20/7/2026, indicating in the cause list that the matter shall be disposed of. Stop. Copy of this order shall be forwarded by the registry to the learned counsel appearing for the petitioner. Stop. Yes, next.
Password item 6.
Mr. Harish Chandra Sahoo for the petitioner.
Family Court, without assessing the income of the petitioner, arbitrarily avoided authority in favor of petitioner number 1.
Excellent argument. Excellent argument, but it should not be arbitrary. So, from your pleadings and evidence. My lord.
You lost it, kindly see the Annex 3. Everything I have
Pleading. It is not a writ petition. You are a regular High Court practitioner. You start arguing revisions like writ petitions. An excellent argument. Arbitrarily, the learned trial court family court has awarded. So don't make an arbitrary submission. Be consistent. Don't be arbitrary. Show your pleadings before the trial court and how it was evaluated. What was your evidence?
My lord, Annex 2, may kindly turning the 21. That opposite party is an innocent person and he is a daily wages laborer. He
केटा आपन को फेवर है ना अगेंस्ट आर्ग्यू करछु वो टोटल अवार्ड केते हिची
13,000 टका
10,000 per month. ठीक है. ଆପଣ proof कौन देले? Daily wage labor ର.
That is annexure 3 by 1.
अरे annexure exhibit कहबे ना annexure कहबे तक. Lower court रे exhibit केते सेटा?
That is not related.
काहे ताले एठी समय नष्ट करूछन? Sir, don't be arbitrary. I can't be arbitrary like the trial court.
That's one part of the code.
Say, sir, in all matrimonial matters, the lawyer is the favorite whipping boy. He is to be whipped right and left. Sir, glancing is a arbitrary and illegal also.
Illegal.
So I should not glance. Glancing over other material is arbitrary, like you have said, the trial court, or arbitrary on the part of the High Court, and also illegal. Lack of non-application. As very aptly said by lack of application of mine. I don't want to invite that. Fault seta fault no seta. KBB Sindhi, he is a learned colleague of you. No advocate worth his salt will not exhibit whatever was adduced by the petitioner. Glancing is illegal, mister. I'll record and I'll say that you are relied on something which is illegal. If you want to damage and spoil your case, I have no difficulty, but I will record that. Because again, the Supreme Court lawyer will say that the laches on part of the learned counsel appearing before the High Court. The High Court has taken note of extraneous material which was not before the trial court into consideration and passed orders contrary to the known canons of law. This argument you will invite. So I don't want to be like arbitrary like that. Which provision can be remitted? Apart from praying. I am not God anyhow, even though you are addressing me, my Lord, all these things. Apart from praying, what is the provision of law? Many times I am tempted to record these submissions regarding the lawyer and say that this should not be done. But I am not doing because you are also a lawyer. I have come from bar being a lawyer for quite a time. This is not done, mister. Every time, at the instance of the petitioner, he should have filed a petition there for something, suppose. For adducing evidence or something. For recall of witness. There are so many provisions. And I mean, blaming the lawyer, laches of lawyer, Annexure 3 was not filed. Date of Annexure 3?
Just 21. From just 21. This some of that.
So look at the very intelligent and eloquent petitioner's evidence, what he has stated in the examination in chief. That will be blamed on the lawyer also. Not done, sir. I will not be a party to all this. So let us not look at materials not on record before the Lord trial court, which is illegal, arbitrary. Also invite a comment like while you are commenting on the Lord trial court lawyer, your colleague. This interest of injustice. Injustice. Looking at other material and remanding matter, otherwise perfect order is injustice. I can't say I am doing justice, I am doing injustice. All parties are equal before the court. You are not your client is not a better person than the other side, lady or the child. You have to tell him the law. If he wants to challenge on any ground, he has to deposit the amount, pay the entire amount, then future he may take a chance. Like many times you will find, you have to listen to understand. Many times you will find permanent liability challenged in Supreme Court, 20 lakhs, Supreme Court converts into 50 lakhs. Then appeal to what? So you must understand. You must understand that there is a still if you are saying if fatally these are all nothing. Actually, these are all afterthought and lies against the lawyer. Let us assume you have a case. Then what should be your strategy? Deposit the amount, fight out the case. Let us see what is happening. Apart from blaming the lawyer and saying lies against the lawyer, there are other things to do. The weakest strategy is to blame the lawyer and blame the court.
That is, as on today, that is the 169,000. 1,69,000.
Deposit. Make it 1,70,000. Deposit.
1/4, sir.
Here I am not here to bargain on decrease. Decree bargaining in which court? Which provision of CPC? That whenever the laborer was a Amirin before the trial court, he was a laborer. So the trial court has not treated him labor to be so.
If also getting the justice order and government benefits, etc., etc.
So always argue, sir, law because children are watching us. Your next generation lawyer. After 30 years, it is every 10 years is 3 generations of can say. They are watching what we are discussing in court. That the wife having a ration card disentitles her for maintenance.
20%.
No, don't bargain here. It is OTS. Upon a deposit to future that much I can do for you.
Beyond my capacity.
So it is beyond capacity of law, much less a High Court judge. Here I am serving law or I am serving sympathy and nonsense. I cannot. Upon jehetu mate कहउछन्ती address करछन्ती बहुत बढै कि मु जा चाहिए ता करिवि. Cannot. Is it possible? It cannot be. I have to follow something. I have to some semblance of respectability. This item. So Harishchandra Sahoo for the. He has chosen you for your name, benevolence or what? Correct, sir. Raja Harishchandra was a Dani. So the petitioner has chosen you for that or what? Don't do that. You have to look up, take care of your profession. So he doesn't take care and blames lawyers. Let it be. The petitioner husband is before the matter was passed over when it reached and is heard again after the, is heard and the learned counsel for the petitioner is heard being present on when the matter was called after recess. This is the post lunch. Would have to take down making post lunch. The petitioner husband is before this court. Challenging the judgment. You can take your seat. I'll take some time in giving the details. Challenge. The petitioner husband is before this court seeking revision under section 19 into bracket 4 of the Family Courts Act of the judgment dated 30/4/2026 passed by the Lord Judge Family Court, Jajpur in criminal proceeding number 112 of 2025. The criminal proceeding was filed by the wife in the marriage and the minor son born from the wedlock, represented through the mother guardian. Minor son like minor daughter and a daughter, represented through the mother guardian. Claiming 6,000 for the wife per month and rupees 4,000 for the minor daughter. The sentence the petition was filed. The CP was filed CRP was filed under section 125 of CRP, 144 of BNSS, 2023. And then claiming monthly maintenance 6,000 for the. Yes. The petition was favored, however. Granting 5,000 to petitioner number 1 wife and 8,000 for the child. Para. To challenge the order, it is submitted by the learned counsel for the petitioner that the learned judge family court has not taken note of the materials on record and he relies on Annexure 3 series to the writ application. Stop. On being asked whether the Annexure 3 series as annexed to the writ application were filed before the learned judge family court, filed oblique exhibited, the learned counsel fairly concedes that those documents were never marked as exhibits, nor were stated in the pleadings, nor were referred to by the petitioner in his deposition before the learned judge family court. The petitioner before the learned judge family court, the mother as well as the wife in the marriage, examined herself as PW1. She examined her brother as PW2. Eight exhibits were marked on behalf of the petitioner, 7 being medical prescriptions and medical bill, indicating medical expenses, record of right, indicating the land recorded in name of the opposite party husband, were marked as exhibits. The present petitioner, being the respondent, examined himself as RW1 and her mother as RW2. He did not exhibit any papers supporting his contention, denying liability to pay maintenance. Learned counsel for the petitioner is apprised of the law laid down by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the Apex Court has authoritatively laid down the principles of revision to be exercised by this court when considering judgment rendered by the learned family court. Next, the learned counsel is also apprised of the decision rendered by the Honorable Apex Court in Rajnesh versus Neha, wherein it has been held that the paragraph would actually reproduce instead of typing it again. Consider Rajesh Patla correction. Rajnesh versus Neha, hint wherein it has been held that the amount directed to be paid as maintenance to wife and child is akin to a money decree. Stop. The learned counsel is also apprised of the provisions contained in the Code of Civil Procedure, Order 41. 1, then into bracket 3, then Order 41 rules 1 into bracket 3, comma 3 dash capital A, comma 10 and 11. The paragraph of पूरा रहेगा. The petitioner shall file upon kichi dena instruction. Upon instruction, the learned counsel for the petitioner commits that the petitioner has not paid any amount towards maintenance for the wife and child. ଆପଣଙ୍କର ସେ କାମ କରୁଛନ୍ତି ବୋଲି ତାଙ୍କୁ ଆକ୍ଚୁଆଲି ବା ରେସନ କାର୍ଡ ଅଛି ବୋଲି 5,000 ଟଙ୍କା ତାଙ୍କୁ ଦେଇଛନ୍ତି, ନହେଲେ 5,000 ଟଙ୍କାରେ ଆପଣ ନିଜେ ଚଳିପାରିବେ? ମାନେ ଆଇ ମିନ୍ ୟୁର କ୍ଲାଏଣ୍ଟ ଲେବର ଯେ ଆପଣ 5,000 ଟଙ୍କା ଚଳୁଛନ୍ତି,
Delhi level list was
The learned counsel for the petitioner submits that he is a daily laborer. Petitioner is a daily laborer. In response to the said submission, the learned counsel for the petitioner is apprised of the decision contained in.
So,
Sir, how it is relevant? How it is relevant? You are saying, Ajit, that she has owned Kon Banega Crorepati. So she has
if a person is a laborer, affidavit not required to file. Affidavit, assessed liability affidavit not required to file. I don't pleading the part of order.
required to file International Court of Justice. I will distinguish Rajesh versus Neha. Wherever because the court, have you read Rajesh versus Neha? Is there any exception? ସେଟା ସେମିତି କାଢନ୍ତୁନି ୟାଡୁ ସେଡୁ କାଢିଲେ ଏଇଆ ପରିଣତି ହବ କରୁଣ ପରିଣତି ହବ ଆପଣଙ୍କର ଆଇଏନଏସି ଅଛି ପରା ଇଣ୍ଡିଆନ ନ୍ୟାସନାଲ ସୁପ୍ରିମ କୋର୍ଟ ଅଛି ଏସସିସି ଅଛି ବାରରେ ଲଗା ହେଇଛି ଆପଣଙ୍କର ଏତେ ଇଏ ହ୍ୱାଟ ଇଜ ଇନିସିଏଟିଭ ଅଫ ଏତେ କଥା କଲା ପରେ ଆପଣ କୋଉଠୁ ଆଣିବେ ଯୋଉଥିରେ କହିବେ ଯେ ଡେଲି ଲେବରର ଫାଇଲ କରିବା ଦରକାର ନାହିଁ କଣ କହୁଛନ୍ତି ସୁପ୍ରିମ କୋର୍ଟ has gone to the extent that it shall be treated as law of the land 141 142 ତାକୁ ମୁଁ ଡିଷ୍ଟିଂଗୁଇଶ କରିବି ଆପଣଙ୍କ କଥାରେ ଇମ୍ପ୍ରେସ ହେଇକି ଯେହେତୁ କଣ ମିଳିବ ସେଥିରୁ Now I need to be obliged that actually I have kept this. As a student of law, I have still studying. So he has no capacity to pay. In response to the said submission, the Lord Council is apprised of the decision of the Honorable Apex Court. The capacity to pay. The petitioners, the Lord, it is upon instruction, it is submitted by the Lord Council that the petitioner remains in default of paying the amount to the wife and the child at the rate of 13,000 per month from the date of the application, that is 28/2025. 28/25 or 28/26, the total amount up to June 2026 comes to 13,000 bar. The petitioner shall file affidavit indicating how he will secure the amount for sustaining the challenge, sustaining the revision. Yes. The matter shall be listed for fresh admission in the week commencing 27/7. The affidavit shall be filed by 24/7. Law ta ଟିକେ ବୁଝାନ୍ତୁ. In this matrimonial jurisdiction, it is happening that you are becoming a student of law of the petitioner or the wife. Chipti karantu. Yes, next.
Achor item 9.
Pratap Chandra Mishra Pada Krishna.
Is a case of
Opposite party is a fresh matter, na? Blank. Opposite party blank.
Blank. Huh? I'm for the husband.
See.
I'm for the.
Kali hitla. Tapore already chota dekhi de.
I'm for the OP wife.
Yes, please.
Husband filed on.
Kindly look at the order. It was earlier heard 22/26. Kindly place that 22/26 order ta. Paperless se dekhi do turant. This is TRPC 163.
TRPC
163. ठीक है.
120 of 2026, which is pending in the court of learned judge.
TRP no again. TRPC before this court is
163. 163.
Just kindly go through the order. Place it. निजे पढ़न्तुनी. Unless you read how I will know what you are doing. In a court, এটা ଆପଣ chamber ରେ ନିଜେ ପଢିବେ ନା. Court ରେ ଆପଣ ମୁଁ ତ ଫେର ଶୁଣିବି ଆପଣ କଣ ପଢୁଛନ୍ତି. Hard Lord Counsel for the petitioner ପାଇଲେ. Vice Chair. Yes, please read that. Place it.
Hard Lord Counsel for the petitioner. The petition submits that the filing of CP number 120 of 2026 before the learned judge family court Jajpur by the husband under section 9 of the Hindu Marriage Act is only to harass her. In response to the said submission, the learned counsel for the petition is apprised of the provisions contained in Hindu Marriage Act, Family Courts Act, Code of Civil Procedure, which provides and defines the territorial jurisdiction where the application under Section 9 of the Hindu Marriage Act can be filed. On being further asked, the learned counsel for the petition submits that the wife has filed 2 FIRs against the husband within the area of Bhubaneswar before police station such as Info City PS case number 149 dated 23/2/2026 and Bhubaneswar Mahila PS case number 250 dated 30/8/2025. The learned counsel for the petition has adjournment to obtain instruction whether filing of application under Section 9 of the Hindu Marriage Act at Jajpur would amount to harassment. The matter shall be listed for fresh admission. From that date, my associate, I was, because my maternal aunt had died, therefore I was not present. My associate was conducting the case on Baischa.
So your associate, has he committed any mistake in mentioning the facts? I don't think.
No,
I try to record facts after verifying.
That fact. So the case was instituted in the, that is correct, that is in the Learned Judge Family Court Jajpur, where this petition has been filed for transfer to the Family Court Bhubaneswar 1. Because the wife, the present petitioner, who is the opposite party in the...
Did you ask the lady that whether she wants resumption of matrimony or what? What is your stand there? Did you ask these questions?
Because at the time of marriage, suppression was
at the time of marriage.
Suppression was made because the petitioner who the
Mr. Misra, कौन question कौन उत्तर कौन दोचोटी? Section 9 रे कौन marriage?
Restriction of conjugal rights.
Section 9 रे, what is the stand of the lady before the court? What would be the stand? What she wants?
So for my instruction,
always, and this is a challenge actually for us, because we come with our own predilection and notions. Very difficult to act impartially. For a judge, it is the biggest challenge. I may say that yes, I am sitting without completely blank and blind, thinking. So whenever you are making a submission, as a lawyer also, don't have the version what your wife has said, what the wife has said to you. Don't be judgmental about the issue. Something was hidden, something was that. You have to simply ask her that what she wants. That she wants to resume the matrimony, or she wants to resist restitution. That is the question put to you. For that, you need a one-line answer.
That I am submitting.
So give a one-line answer. Let us not waste time.
So far as
she wants to resume the matrimony or not?
No, she does not want to.
That you should say, or say that during the marriage there was suppression of material fact. So
good for marriage kartila. Seita कहବାକୁ चाହୁଥିଲି, that was suppressed
before.
before.
Be कहibeni. We are being watched. How do you know? Did you attend the earlier marriage?
No, that I have annexed. That marriage certificate has been annexed.
So you don't go by that. For very many reasons, a lady can say that I have not resumed the matrimony. Suppose he would not have married earlier. So he's a divorcee. The present husband is a divorcee.
Divorce.
So he is divorced. He's divorced.
Divorced.
So maybe he's not divorced. Still, the wife will want may not want resumption of matrimony. If you are, setting a parameter that in case of married men, the wife will not resume the matrimony for the second marriage. That cannot be. You have to say that you have talked to her, and because there is a purpose. Because if there is a Section 9, there will be counseling. The opportunity has to be there. And the delay in counseling creates a situation where the emotion and feelings get crystallized. Animosity or the ill feeling, or you say that feeling of whatever, sour feeling, whatever term you use, that gets crystallized. And in the process, we are not allowing anything to happen because that's a mandate of the statute. So that is the purpose. If she wants that resumption of matrimony, then there is a possibility of reconciliation.
So what is going on in Family Court Bhubaneswar, that can be done at Bhubaneswar, because both the parties are residing at Bhubaneswar. Therefore, it will be convenient for
you want to win the Section 9 case, you should have taken the plea that this court lacks jurisdiction. That is a very surprising approach, I find. That if the court lacks jurisdiction, the matter has to be transferred. If the court lacks jurisdiction, the matter has to be dismissed. Question of jurisdiction is a question of law or mixed question of fact and law?
I'm not questioning the question whether the jurisdiction.
So then you should not argue that, because it is not at the convenience of the parties that say Jodi Chaibe City Haba. That is not there because every court is overburdened.
Distance
Anyway,
100 kilometer distance.
Sir, there are petitions filed 1,000 kilometers apart, 2,000 kilometers apart. So, setare kon achi ki? Odisha to 600-800 hi paribar aapse. Geographical location dekile. Hard Learned Counsel for the petitioner.
Citing to judgments of Hon'Ble Supreme Court, where transfer has been done on the ground of distance, and it is convenient to the wife.
Correct.
Distance.
So, can I exercise that jurisdiction?
No, that I am citing.
Citing, but can I exercise that jurisdiction? Mr. Mishra, don't forget the obvious. This is a interstate and that is intrastate.
That is at Delhi. One case is that Delhi.
Delhi, Purnia.
Delhi, Vitere.
Delhi and Purnia. The cases were initiated at Purnia. Yeah. That power is not with High Court. Even nowadays, Supreme Court is saying not transferring, you use the CP. Sorry, what is that? ICT. The reason being somebody is at easternmost part of the country and the ladies at westernmost part of the country, north, south. Several cases, they are not transferring. You use the ICT facility. That is the latest trend.
Video conference.
Obviously.
BC.
Because the husband is not a lesser mortal. That wherever the wife wants in India, the wife staying in Kashmir, the husband stays in Kerala, and he has to be transferred to Kashmir. And in fact, I don't have the jurisdiction also.
Our case is not like that. Both the parties are residing in Bhubaneswar.
Jeତେବେଳେ client ଚାଲିଯିବ ଅନ୍ୟ ଷ୍ଟେଟ୍ କୁ ସେତେବେଳେ ସେଟା ସୁପ୍ରିମ କୋର୍ଟ ରେ ଆର୍ଗ୍ୟୁ କରିବେ। ଏଠି ବର୍ତ୍ତମାନ ଲାଭ କଣ ତାର?
In this case, both
ଆପଣ ଇଣ୍ଟରଷ୍ଟେଟ୍ ଟ୍ରାନ୍ସଫର ରେ ଦେଖନ୍ତୁ କଣ ଅଛି। ଇଣ୍ଟରଷ୍ଟେଟ୍ ଟ୍ରାନ୍ସଫର ରେ ଆପଣଙ୍କର that Sarvana versus Aishwarya. And that is a case where that completely opposite to your facts. ଆପଣ ଯୋଉଠି criminal case file କରିବେ ସେଠି ହବ। That is not the case of the Supreme Court has not held.
Section 13 petition has been transferred to Bhubaneswar from Kotak. That in my case, one case, I will also.
Obviously, we are liberal. We are achieving nothing.
Bhubaneswar Kotak भी जाइए।
होची।
Kotak ରୁ Bhubaneswar भी
but ସବୁ କୋର୍ଟ ଦେବେ ବୋଲି ମାନେ ଅଛି କି?
ନା ସେଟା that is ଆପଣ କହିଲେ।
So ସେଇଟା ଆପଣ ଯୋଉଟା ସାଇଡ୍ କରୁଛନ୍ତି Supreme Court decision, that is interstate. And I will cite decisions where Supreme Court has not allowed interstate transfer even. So you must, when you are presenting, you have to present the complete set of facts. And wherever, because your case is that since the wife has chosen to file 2 FIRs in Bhubaneswar, so it has to be at Bhubaneswar. That is not case in Aishwarya versus Sarvana.
No.
Aishwarya versus Sarvana देखिए?
No, that is
against you.
That I have got that.
That is against you.
Another is also Sumita Singh versus Kumar Sanjay. That was also.
Sumita Singh, Kumar Sanjay, where the cases are filed?
Maternal proceeding filed by the husband against her in Ara.
Ara को पूर्णिया को उतरी.
Ara Bhojpur to Delhi.
Ara is in Bihar, mu Purnia ko uthile. So Ara to Delhi, Purnia to Delhi, same thing. Those cases are not in your favor. Because you have to show that some citation where Supreme Court wherever the husband has filed, the wife has filed 2 cases, like criminal cases, there every case should be at there. Because that cannot be the interpretation of section 9, 24, 13, so many sections. Nowhere it is there. Even 24 says convenience of the parties, not one party.
Both parties. Interest is in
obviously. Pratap Chandra Mishra for the petitioner. Hard Learned Counsel for the petitioner. The petitioner wife in the petitioner before this court is the wife in the marriage. She like wife in the marriage. She seeks transfer of CP number 120 of 2026 pending before the Lord Judge Family Court Jajpur. To the Court of Lord Judge Family Court, to the Lord Family Court Bhubaneswar. On 22/6/2026, the following, after hearing the learned counsel for the petitioner, the following order was passed. Quote kar deva. 2, 3, 4. Para. The learned counsel for the petitioner makes his further submissions and submits that the petitioner is not willing to resume the matrimony at this stage. Therefore, she will register the application filed under Section 9 of the Hindu Marriage Act. He submitted that the petitioner, after her marriage has run into rough weather, stays with her parents. Our stand kon?
Our stand?
Our stand no, apanakara stand kon, he was staying with parents.
No, brother at Jhatpada.
The petitioner stays with her brother at Bhubaneswar. এটা লোক উকিলଙ୍କ আড্রেস না ନାଇଁ କଣ?
ନା ନା ରେଣ୍ଟେଡ୍ ହାଉସ୍ ରହୁଛନ୍ତି ଝାରପଡ଼ା।
କିଛି ଲେଖି ନାହାନ୍ତି ତ, ସେଥିପାଇଁ ପ୍ରେଜେଣ୍ଟଲି ରିସାଇଡିଂ ଆଟ୍ ପ୍ଲଟ ନମ୍ବର ଏତେ, ଗ୍ଲେନ୍ ଏତେ, ମହାଦେବ ନଗର,
ଝାରପଡ଼ା, ଭୁବନେଶ୍ୱର, ଲକ୍ଷ୍ମୀ।
ଡଟର ଅଫ ଅଜୟ ମଲ୍ଲ ଲେଖିଲେ, ତାପରେ ଆପଣ ଆଡ୍ରେସ ଯୋଉ ଲେଖିଲେ staying with the brother, ସେଥିପାଇଁ I was asking you that since you have written daughter of so and so, whether you are staying with parents, ଆପଣ କହୁଛନ୍ତି ସେଟା କିନ୍ତୁ
ବ୍ରଦର
ଠିକ ଅଛି। ଆପଣ ଲେଖିଲେ Bhubaneswar, she finds it difficult to attend the matter at Jajpur. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Returnable date be fixed to 10/8/2026. The matter shall be listed for orders in the week commencing 17/8/2026. आइए, hired learned counsel for the petitioner. Issue notice, he reiterates his submissions as noted above. Issue notice as above. Accept one set of process fee as well as postal requisites. The returnable date as well as the next date of listing shall be as directed above. In the interim, it is directed that CP number 120 of 2026 pending before the learned Just Family Court Jajpur shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter. Yes, next.
Serial number 20.
এটা পাস ওভার নো?
না।
Sir.
My lord, item 20 on behalf of Mr. Parida, my lord, kindly to stand.
You are Mr. Sahoo?
Yes, my lord.
Yes,
Pramod Kumar Sahu.
PK?
Yes, my lord.
Mr. PK Sahu for the PK Sahu on behalf of Subhendu Kumar Parida for the petitioner. The matter was presented before this court on 7/5/2025 and is taken up for the first time as it has been listed for orders. Stop. Adjournment is sought for on behalf of the learned counsel for the petitioner on ground of personal difficulty. Stop. To grant further opportunity, the matter shall be listed for orders in the week commencing 27/7/2026.
21.
Your name, sir? So A.K. Stichandan for the petitioner. Same order. Date kebe korchanti?
27.
27. Presented before this court on 5/7 ନା 7/5? ସେ ଆଗ ଲେଖା ହେଇଛି 2025-5-07। affidavit ଟା ଦେଖିଲେ ଜାଣିପାରିବ, ମତେ ଦିଅ କଣ ସେ ଫର୍ମାଟ ଆଜ୍ଞା ଚେଞ୍ଜ କରନ୍ତୁ, ଇଟ୍ ଇଜ ସୋ କନଫ୍ୟୁଜିଂ। ଏଇଟା କେତେ କୋଉ ଆଇଟମ? 130 ଶ୍ରୀଚନ୍ଦନ ଫାଇଲିଂ ସ୍ଲିପଟା ଦେଖୁନାହାନ୍ତି? The matter was presented before this court on 30/4/2025. और देखिए लिखिए होता है तो डेट भूले. Yes, next.
22
Vidhandan Pradhan. Petitioner none. None appears for the petitioner when the matter is called. Matter was earlier heard. No, no. The matter was notices were issued on 17/6/2024. The notices were in. Notices were issued. The notices were issued by the coordinate bench by order dated 17/6/25. Mr. Bose, you are running down the stairs, climbing up the stairs, running. No, no, you should not. Never do that.
I'm telling them to get ready and do.
No, no. Even if that happens, but you sit there. Don't do that. You have been allowed to do that. Your consultant has told you that he will run up the stairs. Because I told you this, I did not want, but now you can realize why I am telling you this. Kindly take your seat. Yes. By order dated 33/2026, the notices were made to be sufficient due to refusal on part of the addressee, opposite party. Stop. After hearing the learned counsel for the on the said date, after hearing the learned counsel for the petitioner, the propositions of law as well as the facts were noted, and the learned counsel had adjournment to address on the issues as well as noted. Stop. Today, the matter being listed for orders, none appears for the petitioner. To grant further opportunity, the matter shall be listed for orders in the week commencing 27/7/2026.
23
Notice. And the notice given by the registry is like this.
It is sufficient. AD return.
Yes.
So, it is last. It is the latest. Could be the latest.
Notice on.
It is फेरला देखियो पड़े. So, मैंने बड़े-बड़े के समय लगे, they contact the lawyer and all these things. Obviously.
My lord had issued notice on 2/5/2026.
देखिए, out 2 weeks जाओ. Mr. AP Bose for the petitioner again. आशीष वकलत ना मा.
नहीं 5 ready.
मेरा 5 जो 2-5 से मोर भी से भूल होची आपण जो उल्टा लेखु चोली. आपण अगर तळे डेट देखंतु से 10 गत करछन 6-7. आपण देखछन 20/26 गैस 5 गैस 0. The office note, the AP Bose for the petitioner. The office note dated the office note indicates that the notice has been sufficient. AD has been returned after valid service. However, no counsel has appeared on behalf of the opposite party. So, तଳ कोर्ट रे appear करछनी. सेठी आउथरे कोटे देखियो नेक्स्ट डेट रे कर नै जिबे ना. एथिरे stay अछि ना कोन.
No, maintenance has been refused.
अच्छा. Awaiting the appearance of the opposite party, the matter shall be listed in the week for orders in the week commencing. 27 registry shall verify at put of note accordingly.
One thing should I say?
Yes, please.
Section 9 was being moved, I was sitting behind. Your lordship permit, should I assist it?
Yes, yes.
But what is section? It's a restitution. Either wife will go or not. When Justice Roth was there.
No, Mr. Bose, actually the problem that I am not asking. In section 9 application, what is the usual written statement? The defense is that
Either I yes or
no.
Either I will accept the restitution.
No, there I beg to differ. Because section 9 is a precursor to section 13. So section 9, usual. Section 9, the reply is the petitioner cannot take advantage of his own wrong. I am being tortured. I have been driven out from my home. So in that case, conciliation will work. Counseling will work. Because if the petitioner will say, I am ready and willing. Usual stand is like, maybe a lawyer like you will say that I am ready and willing.
But
these are so usual defense in section 9 is that torture and cruelty. Same thing. But despite the mental and physical cruelty or whatever, or desertion even, can be desertion. Desertion can also be defense in section 9.
Yes.
Desertion, I have left the matrimonial home, but I am ready and willing to go to my wife or husband, as the case may be. So there is a possibility that things will work out. But like what Mr. Mishra was saying, that the wife says she was not aware that her husband is a divorcee, or maybe he is a widower. In that case, perhaps it will not work.
No, but
because that itself relates to a ground of what you call mental torture by suppressing material facts.
But in a section 9 application, the court cannot grant a decree of divorce.
Never.
Counterclaim to that.
Never.
Then what happened? These matters were being heard by Justice Roth. There I had also the occasion of assisting court in that. There, Justice Roth made a project that used to ask, as rightly my daughter asked, that whether you want to reunite or no. If you want to reunite, then we'll call. You'll file a written statement.
There I beg to again differ, because then I am sacrificing the provision contained in Family Court Act, sacrificing the provision contained in Hindu Marriage Act regarding mandatory counseling.
So
mandatory counseling,
ultimately
right.
Happen in section 1. Suppose there is a decree of restitution. Can the decree be executed under order 21 rule 30?
Can be.
Cannot be.
Can be.
No, it will not be.
No, it can be. Read that judgment by Justice Krishna and Sahoo. Mr.
Person.
If suppose a decree of granted section 9 has been granted, we asked, because it has been argued, section 9 constitutional virus has been challenged, because the wife's independence is compromised by section 9, similarly by husband also. So that's in that Andhra case. In that Andhra case, Supreme Court held that it is constitutionally valid. Now, in one matter, Mr. Abhinandan Pradhan was arguing, not Abhinandan. Abhinandan just now, I think. So I am, no, not Abhinandan. It was argued by Mr. Das. I'm just, first part is that I'm just forgetting. So we had to get a security of 2 lakhs. I don't know what happened to that judgment, because that's MATA, of course.
Yes. In MATA, my lord has
MATA, the other court, sitting with Justice Krishna, we have passed a order that because strictly speaking, it is enforceable, but physically impossible.
No,
because we cannot say we can like production warrant, like handing over of possession. Can you do that? You cannot.
Generally, a section 9 application is, if allowed, it is a stepping stone for getting a decree of divorce.
So that was my opening remark.
Yes.
That with greatest of respect, since section 9 is a precursor to section 13, the usual defense is the petitioner is taking advantage of his own wrong. I am not a deserter.
No.
There is no,
I'm only on one point. Transferring section 9 is of no effect because subject to correction. I'll be also arguing that matter if I say.
No. You see, you are supporting me, so why should be? In fact, I have been
Because
telling this openly that because I am trying to at least contribute to that extent.
Section
Whatever I have
9
understood.
What will happen? Unless there is a decree or there is an application on the 13, which is a contested one. Section 9, even if I don't contest, let there be expanded. Can I be forced to do it? Practically impossible.
Finally, you can challenge it. Only way is that if section 9 application is challenged, the wife has to furnish a security.
Yes.
To that extent, 1 lakh, 2 lakh.
Yes.
But if you ask my personal, I am not fully 100% that whether it can be enforced. But it has been done. At least this court has done in a division bench.
No, that power is an unlimited power.
Yes.
There is a provision in the statute, 2132 speaks how to execute the restitution decree.
Conjugal rates.
Yes, my lord, that is the provision. Because property को attach कला पर जब से न आसिबो ताकू बिक्री मत से जियो को को जहां को दे
जे आपण अल्टीमेटली तो आपण बैटरी बंद रिज्यूम कर पारले
ना
तो 3 लाख टका कोन पाइ प्रॉपर्टी जगह रे से सेम सिक्योरिटी 2 lakhs.
Yes.
Wife is not a
decree cannot be executed. That is not right proposal. That can be executable.
Let the situation come.
No, 13 actually that is how I am reluctant to transfer 9 matters, because if the wife is willing, let us not add more fuel to fire. Even notice chalibo. So it goes on. In fact, that is how I was telling Mr. Mishra that don't make, why you are so impressed with the submission of the wife. The husband is married. ଆପଣ କଣ ଯାଇଥିଲେ ଆଟେଣ୍ଡ କରିବା ପାଇଁ? ଆପଣ ଶୁଣିଲେ ଚୁପ ରହିବେ. So you have to be always the lawyer.
My lord is now sitting in this bench. If in case of section 9, how it is started? My lord, I will argue on the question of
my reluctance to transfer section 9 is on that reason.
Yes.
That the parties, if there is a hope of reunion, resumption,
then we should not
and there are the marriages are already crowded. Somebody is alleging is the brother and sister-in-law, without realizing that his life is also ruined. The fight between the couple results in fight between the other couple.
Yes.
Now the family is affected today 12-year-old boy and child.
I kindly remember
this goes on.
Your lordship was sitting in the honorable division bench. Both parties, their daughter went to there and this daughter went. Both was disturbed. Your lordship tagged up both the matter, called both the parties, and ultimately, with your lordship's sincere efforts, I would thank this honorable court for that. Both the parties settled.
No, it has to be.
And both the parties settled.
Only TRPC is, okay, when the petitioner comes to you, do you have a choice of refusing the brief?
We are discharging our duties. But
in a matrimonial cause, there are larger picture to
the
that.
society is to be seen also.
Yes.
And my lord has to see both the sides. We will see one side. But your lordship, while delivering a judgment, has to see both the sides. That's why your lordship started the most difficult job of is to become a judge. And it's absolutely correct.
So because we can't have our minds as
your lordship has
completely wiped out, clean slate. We have some biases,
Yes.
some credit.
I would not say biasness. I would say it is social engineering. That your lordship has to see the social network also. Not that because your lordship is you follow the rule book. It's not. Your lordship has to see the face beyond veil also. That is the reason it becomes a difficult job. Correct.
Next.
24.
24 से adjournment मागिଥିଲେ ସେଥିରେ adjourn କରିଦିଅ Mr. ଆଚାର୍ଯ୍ୟ ନଥିଲେ ଦେନ୍ ଆଚାର୍ଯ୍ୟ Mr. କହିଲେ ଭୂୟା କହିଲେ ତାକୁ adjournment ନିଅନ୍ତୁ ଠିକ ଅଛି
25.
13/7
24
ଟା week commencing 13/7 yes
I'm appearing on behalf of Mr. B.K. Mohanty.
yes please What's your name, sir?
Because
Vikas?
Puran.
Vikas Puran on behalf of PK. You are related to Nicholas Puran.
No.
You are Indian or West Indian? Indian. Mr. Vikas Puran on behalf of PK Mahanti for the appellate. ଆପଣ କଣ extension ଚାହୁଁଛନ୍ତି ନା exemption ଚାହୁଁଛନ୍ତି? There is a confusion. Somebody has says that extension but filed application for exemption. ନା simply adjourn କରିଦେବେ ବୁଝିବେ। ଆପଣ ଯେତେବେଳେ କାଲି ବ୍ରିଫ ଟା ପାଇଲେ ଏବେ ବି ବସିକି ଦେଖିଥାନ୍ତେ ଏଇଟା କଣ ପାଇଁ ଆସିଛି ରେୟା ଟା ଦେଖିବେ so that we have a discussion. That is how everyone starts. It's a vast subject. ପ୍ରଥମେ ଲାଗିବ କିଛି ବୁଝି ହଉନି but gradually you have the grip. This is the IE 76. ଆପଣ ପାଇନାହାନ୍ତି କି ପଇସା କେତେ ପାଇଛନ୍ତି ଜାଣିଛନ୍ତି ଦେଖିବାଟା ଠିକ ଅଛି ଆଉ ଟିକେ କଥା ଆପଣ ଧରନ୍ତୁ 50 ଲକ୍ଷ 10 ଲକ୍ଷ ଟଙ୍କା ପାଇଛନ୍ତି ଆପଣ ସେଥିରୁ ଦେବେନି କାଇଁ କୋର୍ଟ ପେ 68,000 ଟଙ୍କା because I don't think this jurisprudence is that ଆପଣ ଯଦି ଜିତିବେ ତାହେଲେ ଦେବେ ନହେଲେ ଦେବେନି ଏଟା ତ କିଏ ଆର୍ଗୁମେଣ୍ଟ କରୁନାହାନ୍ତି because if that is the principle applied then the concept of court fee goes for a toss. This IA 76 of 2025 copy of the appellant respondent Mr. Naik. R2. So Mahanti for R2. Senior panel counsel.
Yes, ma'am. I'm giving my appearance number.
Ajay appeal kuchhandi.
Hi.
Court re file is na eta
Today just now, if you will not say, online file.
Better on. The IA has been filed for deferment of payment of court fee. Language cannot be exemption. Language has to be deferment. Deferment of payment of court fee for an amount of rupees 68,684. Therefore, kota is close to 69,435. You are right. 69,435. 423. Petition lekha is 435.
Dealership
Yeah,
423.
This jagah bhul lekha is. Yeah. But the secretary see its list. 69,435. Copy has been copied ଦେଇଛନ୍ତି?
Copy, I have not decided.
ଆପଣ Mr. Naik copy ପାଇଛନ୍ତି? Copy of the application appearance से check କରି ତ? ଆପଣଙ୍କ ପୁରା ନାଁଟା ହେଉଛି Mr. R.K.
Alok Kumar Mahanti.
Alok Kumar Mahanti. A.K. Mahanti. Mr. Alok Kumar Mahanti, Senior Panel Counsel. It is submitted by the Learned Additional Standing Counsel upon advance copy served appears and waives notice on behalf of the R1. Mr. Mahanti, Learned Senior Panel Counsel, submits that he has instructions to appear on behalf of the R2. He shall file Wakalatnama during course of the day in the registry. The Wakalatnama shall be taken on record, scanned copy be updated. Name of Mr. Mahanti, Mr. A.K. Mahanti, Learned Senior Panel Counsel, shall be indicated in the cost list as well as the case brief. Copy of the IA shall be served on the Learned Senior Panel Counsel for R2. The matter shall be listed for orders in the week commencing 3/8/2026. The Satyabrat, you Mr. Sodangi. Mr. R.K. Sodangi for the petitioner. Yes, please. So which paragraph of Rajneesh versus Neha is applicable in your case? ଦେଖିବେ ନା ଆପଣଙ୍କର Rajneesh versus Neha also has not dealt with the aspect ଯୋଉଠି 2000 3000 4000 ହବ assets and liability ଦବା କଥା କି ନାହିଁ because the principle is that even a daily wager has to maintain. So ଆପଣ daily wage ହିସାବ କଲେ ତ ଆରାମ ସେ 4000 ହବ ଆପଣ ସେ ପ୍ଲି ଟା ନେଇଥିଲେ କୋଉଠି ଯେ Rajneesh versus Neha ଆପଣଙ୍କ ପ୍ଲି ଦେଖନ୍ତୁ ସେଟା you are not re-arguing the revision. So what was your stand before the lauded judge and how he has dealt with it? Delay, unless you convince on the merits, I cannot issue notice on delay. The law is otherwise. ଆପଣ ସେ +3 ମହିଳା ମହାବିଦ୍ୟାଳୟରେ ଝିଅଟା ପଢୁଛି ଆପଣ ତାକୁ 4000 ଟଙ୍କା ଦେଲେ ଅଧିକ ହେଇଗଲା ଦଉଛନ୍ତି ତ ଆଉ ଦେବେନି ବୋଲି ଚାହୁଁଛନ୍ତି ଲମ୍ବା ଆଡଜଷ୍ଟମେଣ୍ଟ ବର୍ଷେ ଆଡଜଷ୍ଟମେଣ୍ଟ ନେଇଯାଆନ୍ତୁ ଚାଲୁ that way you can help. ଆପଣ କନଫ୍ୟୁଜ ହେଇଗଲେଣି କିଛି ବାଟ ଗଲେ ଝିଅ ସାଙ୍ଗରେ ବର୍ତ୍ତମାନ ଚାଲିଗଲେଣି ସିଆଡେ 13 ଆଡେ ପଳେଇଲେ 1325 ସେ ଅଲଗା ଅଲଗା ଜୁରିସଡିକ୍ସନ ଆପଣଙ୍କର ତାଙ୍କର ଝିଅ ବର୍ତ୍ତମାନ ରହୁଛି କୋଉଠି ଅଜା ଘରେ ମାମୁଁ ଘରେ ରହୁଛି she has a difficulty because now the mother is married. ସେ ପୁରା ସତ କଥା ଲେଖିଛନ୍ତି ରିଆଡମିସନ ଫି 7000 ଟ୍ୟୁସନ ହଉଛି 3000 ପିଜିଡିସିଏ 700 ବୁକ୍ସ ଆଣ୍ଡ ଅଦର ଷ୍ଟେସନାରୀ 2000 ତାକୁ ସେ ବି କେମିତି କାଟି ପାରିଲେ ସେ ଜାଣିଛନ୍ତି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ ଶସ୍ତା ପଡୁଥିବ ମୁଁ କହିପାରିବିନି ସେ ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ ତ ମାନେ ସେ ଫ୍ୟାମିଲି ଜଜ୍ ବି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ ସିନିୟର ଆପଣଙ୍କର ବିଜନେସ୍ ଅଛି ମହିମା କଲର ଷ୍ଟୋର ପ୍ରତାପ ପ୍ରସାଦ she will be asset for you. The daughter will be asset for you. Are you married for you have also married for the second time? Just think about the girl.
Last 15 years.
What she will be asset for you. Madam, the learned counsel for the petitioner is added some length. He submits that notice may be issued in the limitation. In considered view of this court, so limitation notice not to be considered view of this court. Unless the court is convinced regarding merits of the case, notice need not be issued to the opposite party. The Purbur Lekhidiyo to the petitioner before this court is the father and the opposite party is the daughter. Petitioner challenges the judgment dated 2/12/2025 passed by the Lord Judge Family Court Noyagada. Date taken 2/12/Noyagada directing payment of monthly maintenance to the daughter at ₹4,000. The learned counsel for the the learned counsel for the petitioner seeks adjournment to advance arguments. The matter shall be listed for orders in the week commencing 3/8.
28.
Have issued notice. that Lok Adalata award is not a challenge, where I was not made a party and is covered by your lordship judgment at Madhuchanda Chan. But there is no appearance from the other side.
28.
Yes, ma'am.
अच्छा निरंजन पंडा आपका associate.
May I please, my lord? So in this proceeding, I am appearing for the opposite parties. So due to my illness, I could appear physically before this Hon'Ble court. So due to my illness,
काहाको request करନ୍ତୁ Mr. Anupam. Can you please
no,
hear?
I am Niranjan Panda. I am Niranjan Panda, my.
Sir, how many Niranjans are there in court? I was thinking
So,
two only.
I am Niranjan Panda 4. I am Niranjan Panda 4, my.
4.
4, my.
Who is 3?
Who is 3? So my learned friend, who is the district judge of Hon'Ble, Niranjan Panda. He was 3.
See, अच्छा see High Court बाहर थिले वाले 3 थिले.
Yes, my. Subsequently, I joined in this bar.
अच्छा.
So due to my illness, I couldn't file the
kindly listen, Mr. Panda. The point is this. There is no point in keeping the matter pending here. If what is stated by the petitioner and argued by the learned counsel is correct, then this is just keeping the matter pending is of no use to any of the parties. So take that instruction. Already in another matter, Mr. P.K. Satpathy was appearing. When looking at the records, when he realized that the issue cannot be overcome regarding sufficiency of notice, or
it is respectful submission before this Hon'Ble court. So as per the instruction of the opposed party, there is a suit pending before the Court of Learning Civil Justice Senior Division Sahoo. The present petition is filed in suit civil suit number 1070/2026.
That we are not discussing. Mr. Panda, we are not at all discussing that. We are discussing regarding the judgment and decree or order and decree passed by the Lord National Local Adalat. So some very fundamental issues are there which has to be satisfied by such a decree. If those points are satisfied, you have to sell. Then fair enough, keeping the matter pending. Otherwise, there is no point in keeping the matter pending, whether notice was sufficient or not. The order sheet must show. So you have to examine that. That you have to exercise your, due diligence or legal acumen and find out.
So as per instruction, only I know the said suit is pending before the Lord and trial.
आपनकर client सेटा instruction देई परिबेनी. That you have to examine. Like Niranjan Panda 3 has become district judge. Now you have to become that.
Yes, my
Niranjan Panda 3 order. ସେଥିରେ ଆପଣ କୋଉଠି ସୁଟ୍ ଫାଇଲ ହେଇଛି କୋଉଠି ପେଣ୍ଡିଂ ଅଛି କୋଉଠି ସେ ପାର୍ଟି ଅଛନ୍ତି ସୋରରେ ପେଣ୍ଡିଂ ଅଛି how does it
so in this regard I am submitting that before this court date. So this writ petition is not maintainable since another civil suit is pending before the Court of Learning Civil Justice Senior Division Sahoo. So in the said writ application,
wherever a civil suit is pending, the learned judge, National Lok Adalat cannot pass orders by ignoring sufficiency of notice.
So then, so can I suggest
alternative remedy? Alternative, jehetu I would shoot
your lordship may direct the petitioner. He may participate in this said suit.
ଆଜ୍ଞା କଣ ଆପଣ କହିଲେଣି ସେଥିପାଇଁ ଆପଣ ତାଙ୍କ ସାଙ୍ଗରେ ଦେଇଥିଲେ କି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜ୍ ପରୀକ୍ଷା?
So it is by humble submission before this Hon'Ble court.
ଚ୍ୟାଲେଞ୍ଜ ହେଲା ଲୋକ ଅଦାଲତ ଅର୍ଡର ମୁଁ ଏଥିରେ ଡାଇରେକ୍ସନ ଇସ୍ୟୁ କରିବି ଆଉ ଗୋଟେ ସୁଟ୍ କୋଉଠି ପେଣ୍ଡିଂ ଅଛି ସେ ପାର୍ଟିସିପେଟ କରିବେ ମୁଁ ଆଜ୍ଞା
then this matter may be referred to the Civil Justice Senior Division. So in this said suit, the petition may participate as a party.
ଆପଣ ଟିକେ ପଢାପଢି କରନ୍ତୁ ଦେହ ଖରାପ ଥିଲେ ବି ପଢାପଢି କରି କୁହନ୍ତୁ କଣ କହୁଛନ୍ତି ଆପଣ if I record I have to reject it.
What my senior is saying, he says that this may be relegated to that position
and he has not said relegated
So it is my humble submission that since the petition has filed this writ application and the petition has not evaded the party in the said civil suit which has been disposed of by the National Lok Adalat, accordingly your lordship may direct the present petitioner to participate in the case civil suit.
See, he has gone one step ahead of you. He realized that your submission, he said that let that should also be entangled in this matter. I will only confine to the matter pending, which was decided by the learned
Let him
Lok
just
Adalat.
show that I was a party. I have no case. Let him show that I was a party in that proceeding in which Lok Adalat.
So it is my suggestion, my lord.
नहीं,
So he may
suggestion
participate in the
it is suggestion invite करा होनी एठी आपनकर law रे submit करंतु then
the petition may participate in this said proceeding.
Mr. Panda, you look at the order dated 752026.
Yes, my lord.
पढ़ंतु place it.
The IA has been filed seeking leave to file the present petition 9/2023 passed in civil suit number so by the learned senior civil judge Suro. In as much as the present petition was not a party to this suit, her uncounsel for the petitioner is the son, co-sharer of the joint Hindu family property, and he has not been made a party to the suit seeking partition before the learned trial court. Subject to the appearance of the opposed parties and their filing of any reply, leave granted to the petitioner to move this suit in a writ petition. The IA shall be taken up along with the writ petition on the next day. WPC number 1200-764/2026. High Learned Counsel for the petitioner. The petitioner challenges the judgment passed in National Lok Adalat by the learned senior civil judge Suro in civil suit number 372/649/2023. It is submitted that the petition herein is a necessary party before the learned senior civil judge Suro, but was not made a party in this suit for partition. It is submitted that the issue involved is already covered by the judgment dated 6/4/2026 delivered by this court in WPC number 31132/2025. Madhusudana Sahani, L.S. Mohanty, and others, Saroj Kumar Dani, and others, as the issues are similar. It is submitted that the petition herein was not made a party to this. Further, the notices issued to some of the defendants in the suit were not sufficient, as the service return was not ensured before accepting the compromise between the parties to dispose of the suit. Issue notice along with this order.
Mr. Panda, so only you have to respond to paragraph 4. So whether he was made a party, because your submission another suit.
No, my lord. No, my lord. The petition is not made as the party.
So you make him a party and let there be whether both the suits should be taken up analogously, hard analogously. That's another thing. You file another one more brief from Bose and Mr.
Yes, my lord.
So let it be remanded.
Yes, my lord.
And I am not recording. Mr. Bose got encouraged actually. Now he wants to entangle the other suit with this.
No.
Otherwise, why did you say that let both the suits?
No, my lord, he said it.
He said that, but you said that let it be.
My lord, that unless there's a multiplicity, how we will
let us see, sir.
benefit.
So on the ground of maintenance, I have raised that question. So your lordship may remand this matter to the trial court.
Obviously, I will not be observing regarding the other suit or this suit. Simply, it is remanded because the facts as stated are correct.
Yes, ma'am. Yes, ma'am.
Yes.
We agree.
Mr. Amit Prasad goes for the petitioner. Mr. Niranjan Panda, 4. Niranjan Panda 4 for the. But effectively, you are now the 3. The 3 cannot practice in. He can practice in High Court.
So, but in a bad ledger, mentioning the Niranjan Panda 4 by law.
So Niranjan Panda 4 for the opposite party.
Parties.
For the opposite parties.
Yes, ma'am.
Upon notice being sufficient as issued by order dated 25/2026, the opposite parties have appeared through Mr. Panda, to Panda, learned advocate. So Panda, being present in VC, is heard at some length in response to the observations made at paragraph 4 of the order dated 252026. He submits that the contentions raised by the petitioner and argued by the learned counsel for the petitioner cannot be denied to the extent that the present petitioners are not parties in the civil suit number 372/649 of 2023. Regarding the notices issued to some of the defendants in the said suit not being sufficient, as this return was not ensured by the learned judge, learned senior civil judge. It is submitted by Mr. Panda, learned counsel for the petitioner, that the said issue is apparently correct. Stop. Madhu Chanda Sahanir citation upon a
That is WPC number.
So that is it reported now?
I think it is reported.
In so and so, so and so. Relying on the earlier judgments, relying on the judgments of the Honorable Apex Court in Jalor Sikh, Bhargavi construction, the following has been held. Stop.
My lord, another judgment is also. It is delivered by Honorable Justice S.C. Behra. That is also reported. CRP number 17 of 2023. It is decided on 5/1/2026. Baman Chana Swami versus Prabhat Kumar Swami and others.
When Supreme Court is there?
Now it is our own High Court decision. This judgment has been delivered by Honorable Justice S.C. Behra.
Our own High Court decision by Justice S.C. Behra, Madhuchanda Chani no, High Court review.
And there is also Madhuchanda Chani. Before the judgment, there is also judgment in CRP 17 2023.
I don't know whether it has been reflected or not by Justice Behra. In a CRP, that no notice was there.
CRP 17 of 2023.
Here it's a pure case of local falling in the under the Jalor.
So, my lord, there is a principle decided in CRP number 17 2023 date.
Mr.
So,
Panda, did you hear Mr. Bose what he's saying? There is some audio issue with you. He says that CRP was not dealing with a local decision.
Yes, my lord. Yes, my lord. So, in CRP 17 of 2023, in this judgment, Justice Behra has mentioned the National Local Adalat decision. So, it is maintainable. In this regard, the ratio has been decided by our Honorable High Court.
Apana Madhuchanda padichanti ki?
Yes, my lord.
Madhuchanda bhi a High Court decision.
Yes, my lord.
Madhuchanda was dealing with what?
Regarding writ petition is maintainable, challenging the order passed by the National Local Adalat.
Writ petition is definitely maintainable. So when Supreme Court is maintainable, who am I to say? But the question is different.
Yes.
Citation Mr. Panda jota kahuchanti, is it required or no? I don't understand. CRP re the writ petition CRP re kai file kale?
In CRP, Justice Behra has mentioned that against the order passed by the National Local Adalat, writ is maintainable before the Honorable High Court. Article 226 is maintainable.
Sir, CRP.
Obviously,
and sir, agar kon thila?
ଆପଣ ଯୋଉ ରିଟ୍ ପିଟିସନ ମେଣ୍ଟେନେବଲ ନୁହଁ ବୋଲି ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ କି ନା କଣ ଆପଣ ସେଟା କାହିଁ ସାଇଟ୍ କରୁଛନ୍ତି ମୁଁ ବୁଝି ପାରୁନି
No, my lord. Writ petition is maintainable. read petition is maintained.
ଆଗେ ଟିକେ କଥା
ଶୁଣୁନାହାନ୍ତି କଣ କରାଯିବ
ଆଗରେ କଣ ଥିଲା ସାର୍
ସିଆରପି ହଉଥିଲା ତାପରେ
CRP
ପିଟିସନ ହେଲା ହଁ
ସାର୍ ସିଆରପି କୋଉଠି ବି ହଉଥିଲା ଯୋଉଠି ଲିମିଟେସନ ରେ ସାର୍ ଫାର୍ଷ୍ଟ ବିଲ୍ ଡିସମିସ୍ ହଉଥିଲା ସେଠି ବି ସିଆରପି ହଉଥିଲା as per full bench judgment. But when Justice Balsubramanian was here, he sitting with Honorable Justice Naidu in division bench, he disagreed. But because it was a full bench, he did not touch that issue. Justice Balsubramanian went to the appeals court. He rendered a judgment that once this limitation in first appeal is dismissed, it amounts to a decree under order to rule. There, in a passing observation, it was held by Justice Behra that against the local
let us not take name whether the other bench has followed Jalor Singh or not. That I am unable to understand.
But there only was point was that whether repetition is maintainable or not. That already been set at test in Jalor Singh.
That is not relevant. Once the Supreme Court has said,
yes,
and if the court has not noticed Jalor Singh, then what I can do?
No, madam. The court held that CRP was not maintainable. A repetition will lie.
But for that, after Jalor Singh, the court has to notice Jalor Singh.
Yes.
I may say so many things, but not
Jalor Singh is the judgment from which this
has emanated.
This has come, man. Jalor Singh, then Bhargavi, then any other.
Mr. Ponda, you are saying that I mean Madhuchanda, instead of Madhuchanda, the other CRP should be relied on, or what? What I could not get from whatever you are submitting.
So it is my submission that so CRP may also be cited before your lordship judgment.
How CRP read petition? Have you read Jalor Singh?
Since yes, ma'am.
What is the citation? What is the citation of Jalor Singh?
So I am not aware about the judgment.
Sorry?
So I am not aware about the judgment.
Then why you are getting confused, not reading and not being aware?
So your lordship may put that
Supreme Court has held that read petition is maintainable in Jalor Singh. That has been followed in Bhargavi and subsequent decisions. You are saying that in a CRP, High Court has held that read petition is maintainable.
Yes, my lord.
Does it add to any clarity or it adds to more confusion?
Yes, my lord. No, there is no confusion.
And but that is the reason I asked that whether the Honorable Single Judge has noticed Jalor Singh or not. Then you say that he has noticed. Then I asked you that what is the citation? You say that I am not aware. Only clear. Yes, the court hearing. But accordingly, in view of the Lord Counsel for the opposite party, upon the CRP question citation that you
The CRP number 17/2023.
17/2023 decided on
5/1/2026.
Reported.
Yes, my lord. (226) one seller 1236.
It is interesting. Next, direct decision on the part of writ petition is not reported. Because as I said, I don't render any judgment. So now Mr. Ponda is obviously confused. He is citing CRP. So why CRP will be cited in a writ petition, I am unable to still follow.
This judgment, Madhuchanda is not reported, my lord.
The Supreme Court has said. Supreme Court has not said regarding CRP.
So in CRP,
ଟିକେ ଆପଣ ଆଜି କହିବା ବନ୍ଦ କଲେ ଭଲ ହୁଅନ୍ତା ମୁଁ କହିଲା ବେଳେ ଆପଣ କହୁଛନ୍ତି ମାଇକ୍ରେ ଦି ଜଣ ଯାକ କହୁଛୁ ନା ମୁଁ ବୁଝିପାରୁଛି ଆପଣ ବୁଝିପାରୁଛନ୍ତି ମୁଁ ଯେତେ ଯାହା ପଚାରୁଛି ଆପଣ ମୋ କଥା ଶୁଣୁନାହାନ୍ତି 226 1 CLR 1236 ସେ ଇଏ ମଧୁଚନ୍ଦା କିଛି ଖରାପ ଜଜମେଣ୍ଟ ନୁହଁ ତାକୁ ବି ଦେଖନ୍ତୁ
ଆଜ୍ଞା
ଯଦିଓ ରିପୋର୍ଟେଡ ହେଇନି ଖରାପ ନୁହଁ
Yes, ma'am.
Yes. That's what I wish for you. Yes. Less than so and so, 26 1 CLR, এটা কোনো দেখি পারি। পরে এটা দেখি বার করি। କୋଉଟା କହିଲେ?
26 1 CLR.
ଏଠି ନଥିବ ବୋଧେ। ଏଠି ନଥିବ। ଏଠି ନଥିବ। CLR ଏଠି କଣ ଆପଣଙ୍କ ସେ ଆପଣ
They are supposed to give all the.
OLR ଆଣୁଛନ୍ତି ଆଉ OLR ଯେହେତୁ ମୋର କିଛି ମାନେ ମୁଁ ତ ଜଜମେଣ୍ଟ ଏଣ୍ଟର କରିନି ତ ସେଥିପାଇଁ ଆଣୁନାହାନ୍ତି।
ସାର୍ ମୁଁ ଅଧିକା କହିଲେ ତ
ନାଇଁ ନାଇଁ କିଛି ଅଧିକା କଣ ଏଥିରେ କହିବାର କଣ ଇଟ୍ସ ଏ ଫ୍ୟାକ୍ଟ ଶୁଣ ଆଜି ଏ କନଫ୍ୟୁଜନ ଆରାଇଜ କଲା वी हैव टू अराइव एट ए कंक्लूजन ନା ନାଇଁ
ସରକାରୀ ଓକିଲ ଗୁଣ ଛାଡ଼ିବୁ କି
having had learned counsel for the parties, this court, in considered view of this court, in view of the petitioner not being a party in the civil suit number 372 of 49 of 2023 before the senior civil judge Soro, which has been disposed of in Lok Adalat. The entire proceeding, the order and decree, the judgment and decree, judgment order and decree lecture. The judgment and decree dated 24/11/2023 gets vitiated. The same is set aside.
9/12/23 and 24/11.
9/12/2023
And 24/11.
and 24/11/2023 gets vitiated. And the same is set aside. The CS is restored to file. 372 of 2023 is restored to file of the Court of the Civil Judge Senior Division Soro. The petitioner shall appear before the Civil Judge Senior Division Soro on 2 weeks. On 27/7/2026. 30/7/2026. 3/8/2026 on the said date. The present opposite parties shall file appropriate application for impleading the present petitioner as a defendant. If no such application is filed, by direction of this court, the petitioner shall be arraigned as defendant number 3 in the said suit. The defendant number 3 shall have the opportunity of filing a written statement and adducing evidence in accordance with the law. The Lord Civil Judge Senior Division Soro shall proceed with adjudication of the civil suit in accordance with law by giving opportunity to all the parties to the litigation. The petition is disposed of.
One day, that is 5/1/24 when the
So interim order may
sealed and signed. That is my lordship, this date of page 14.
The order dated 2/11 24/11 তারপরে
24/11
9/12
আর 5/1/24
and 5/1/24 5/1/24
the interim order may be vacated by
set ହେଇଗଲା ଆଜ୍ଞା ସେଟା ସେଟ ହେଲା ପରେ interim order କଣ ରହିଲା interim order staying the decree has been set aside and quashed. The learned counsel for the opposite party seeks for the direction regarding the interim order dated 25/2026 passed in IA number 7497/98 of 2026 in view of the setting aside of the decree judgment and decree as directed above. The interim order merges with the final order. Urgent certified copy as per this. Issued as per
29
My lord, your inadvertent mistake was there. My lord was pleased to issue notice to opposite party. My clerk, what he did, he said notice to perform opposite parties. Notice steps are already steps in each. My lordship may direct. Office may accept.
ସେଟା ଆହୁରି ରିୟୁଟିଲାଇଜ ହେଇପାରିବନି?
ନାଇଁ ସେଟା ଅପ୍ରଫର୍ମ ହେଇଯାଇଛି ନା ଆଡ୍ରେସ ଲେଖା ହେଇଯାଇଛି ଅଲରେଡି ଆମେ ଫେସ୍ ବି କରିଦେଲୁ ଆଜି ଇନ କୋର୍ସ ପରେ ନୋଟିସ୍
ଆପଣଙ୍କର ଯୋଉଟା ଇଏଟା
କପି ଗୁଡା
କପି
କପି ମେ ବି ଆମେ ପଠା ହେଇଯାଇଛି ଅଲରେଡି
Today morning.
ସେ କିଛି ଫେରସ୍ତ
ସ୍ୱାଗତ ଦାସ ଫର ଦ ପିଟିସନର ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କଣ ବହୁତ ରିଚ୍ କି?
ନାଇଁ ନାଇଁ ଅଛି ସେଥିଲାଗି ମାଇ ଲର୍ଡ ୟୁର ଲର୍ଡସିପ ୱାଜ ପ୍ଲିଜ୍ ଟୁ
ଦିବେଦିବା କ୍ଲାଏଣ୍ଟ ରିଚ୍
ଦୁବିଧ କ୍ଲାଏଣ୍ଟ ଆକ୍ଚୁଆଲି
ସ୍ୱାଗତ ଦାସ ଫର ଦ ପିଟିସନର. The matter is listed for orders for acceptance of requisites for issuance of notice to opposite parties 1 to 10.
1 to 10.
10.
P1, PO to 10.
Yes, ma'am.
It is submitted by Run Counsel Mr. Das for the petitioner that inadvertently the requisites were wrongly, the addresses in the requisites, in the postal requisites were wrongly mentioned, indicating the opposite parties 11 to 19.
Perform opposite parties.
Proforma opposite parties 11 to 19. Noticing the said mistake, steps have already been taken and requisites for issuance of notice to OP1, TO2,
1 to 10.
19.
1 to 10.
1 to 10, sorry. OP1, TO2, 10 have been filed. Registry shall do well to issue notice to the opposite parties 1, TO2, 10, fixing returnable date to 10/8/2026. The matter shall be listed for orders in the week commencing 17/8/2026.
Interim
order dated
absolute. 7/5/26.
Title 29.
Until further release, that is absolute.
Okay.
Obliged.
Item 30.
Anyone present? Extension of time for what?
Earlier they have taken a direction of this.
30 को order से आवड़े दिनों को रखिए. So Gopinath Mishra for the petitioner, the opposite party now petitioner done, Mr. Naik for the opposite party. IA 117650 of 2026. In absence of the petitioner, learned counsel for the petitioner, the matter is adjourned. The IA shall be taken up on the next date. The matter shall be listed for orders in the week commencing.
Satesh
is at
31.
1 pass over court number 3.
Right now, I cannot continue hearing after notice matters. Unless some short matter is there.
Tomorrow or day after tomorrow.
Mr. Karunakar Naik, Senior Panel Counsel.
Lawrence Senior is.
Senior Panel Counsel for the appellant. Mr. J. Samantraya for the respondent. Court fees sufficient accept.
Yes.
The matter is listed for hearing under the heading for admission. Paucity of time intervenes. The matter shall be listed for admission in the week commencing 10/8/2026. Yes.
32.
The Lalitendu Mishra for the petitioner. The Sahoo Das for the
my lord. My lord, last occasion, my lord, that
total 7,52,000.
let me come. My lord, 1 lakh अढ़ी लक्ष टंका थिला जेतले एडजस्टमेंट हे नथिला एनहांस हे नथिला 1 lakh rupees देथिल but in the meantime my friend has said that some more amount is there. I will take instruction for that. But as per my submission made before my lord, I have paid rupees.
You file this with a memo and serve with your lord.
Yes, I'll serve. and also take instruction.
payment pouchonti to
I kori chalibi tapre yesterday matter was there for my lord amicable settlement, maybe effective hobo no hobo, but it was supposed to be with the honorable coordinated bench, division bench, and they have second
so that's for the petitioner, the Lord and Counsel for the petitioner submits that he has received a copy of the received a statement indicating the amounts paid by the petitioner husband to the opposite party wife in the marriage. The said statement shall be filed supported with a memo, along with a memo. Upon serving copy thereof for the Lord and Counsel for the opposite party, the Lord and Counsel for the petitioner shall obtain instruction.
yes.
The matter shall be listed for admission. It will be commenced.
Satish sir.
Satish sir.
My lord, since the matter is your execution is there on 8th, so my lord, I will file an urgent application, or your lordship may kindly
पैसा दियो
तुम 23 लाख टका देई चाहिए जो पड़ नथिला
bargaining नहीं है.
I will file an urgent application.
Bargaining facility.
I will not bargain. My lord, I will
पैसा टा जदि देबे मु ताले डिपॉजिट कर दियो सेठ.
your lordship may I will file an urgent application, otherwise they will attach my salary. My old mother is in treatment position.
Old mother and the wife's life has no value.
Wife is now working.
So you deposit the entire amount in court.
My lord, that will help. I will take instruction.
Sir, please don't. I'll record and reject. That will not help you. Then you will produce by order before the trial court. So you are too seasoned not to do that.
That I will take instruction.
You are convinced that you will bargain for your client. But I will not pass that order. I will not participate in that whole
I
process
also
of
not
machination.
encourage once
This jurisdiction has been completely requested.
my lord, also I used to advise you first you pay to sustenance of your wife and daughter. That is not done, but she was regularly paying.
डॉक्टर देव बोले जरा भी बहुत हाई टिप मैंने बहुत
माँ को दियो जाए.
माँ
सेते तक कोई भी.
सेठ भी नहीं.
Petitioner को केवल beyond mother से आपको बनाती.
No, that is correct, my lord. That should be. Now, one more thing, my lord.
That is life.
Yes, my lord. Well, one more thing I would like to bring your my lord's attention. Actually, in fact, there was outstanding 7,92,000. They have paid 2,73,000. And the last 24 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ 2,5,19,000 ଅଛି. ଲକ୍ଷେ ଟଙ୍କା ସେ ଦେଇଛନ୍ତି. ଲାଷ୍ଟ ଡେଟ୍ ସେ ପଠେଇଛନ୍ତି ଗୋଟେ ଫଟୋ
ନାଇଁ ମୋର ସେଟା ଇନଷ୍ଟ୍ରକ୍ସନ ବଟ୍ ଏକ୍ଜିକ୍ୟୁସନ ତକ 2,24,74,000
କହିଲେ ଷ୍ଟେଟମେଣ୍ଟ ଯେ 2.5 ଲକ୍ଷ ଟଙ୍କା ଅଛି that's not correct.
Record kali ki?
ନାଇଁ that is what.
My lord, they have filed the execution 2,74,000. Maybe.
More again, I also have lost my hairs and it has grown white out. So, ମୁଁ କିଛି record କରିନି.
Yes, ma'am.
Because Mr. Mishra କିଛି ବୁଝି ନା.
Mr. Mishra is quite rich. The client is also very rich.
No, that is not there. That is not.
ଆପଣ 5 ଲକ୍ଷ ବାହାନା କରି ସେ କେତେ ଟଙ୍କା ଦେଲେ ସେ ନିଜେ ଜାଣି ନାହାନ୍ତି. ନହେଲେ ସେ କହିଥାନ୍ତି. ସେ କିଛି କହିଲେ. Did you mark if you have a replay? ଆଜ୍ଞା total due 7 ଲକ୍ଷ ମୁଁ ଦେଇଛି 5 ଲକ୍ଷ.
ନାଇଁ ମୁଁ
ସେ କହିଲେନି. ସେ କଣ କହୁଛନ୍ତି ସେ ନିଜେ ବି ଜାଣି ନାହାନ୍ତି. ତେଣୁ ଛାଡି ଦିଅନ୍ତୁ ସେ ଯାଉ.
I'll file an application before.
ସେ ଆପଣ ସେଟା ଟଙ୍କା ଦେଇକି ଆପଣ ଯାହା କରିବେ but this court will not participate in adjourning the matter.
Okay. Memo de दी.
Yes, please.
Sir, memo leki.
Please, sir. ଆଜି ନଦେଲେ ହବ. ମୁଁ ଏବେ ଲେଖିନି. ମୁଁ ଡାକିଲି ଯେ memo is filed.
ନାଇଁ memo file କରିବି ମୁଁ କପି ସର୍ଚ୍ଚ କରିଛି.
He shall file a memo. Yes. No, he is pointing out that you have directed, sir.
So that order will also consistently pass out, right? That is
33.
Mr. Santosh Kumar Mohanty for the petitioner. Mr. Petitioner none, Mr. Rajiv Bihari Mishra for the opposite party. For the OP. Revision ne petitioner opposite party now. Because stay ଅଛି ନା କଣ ଆଜ୍ଞା?
ହଁ stay ହେଇଛି ନା 20 ଲକ୍ଷ ଟଙ୍କା ଏରିଆର ଦେଲି 8 ଲକ୍ଷ 10 ଲକ୍ଷ ଅସୁବିଧା ଦବାକୁ ପଡିବ ଲକ୍ଷ ଟଙ୍କା ଦେଇକି stay ଅଛି
ଆପଣ ଏଟା କଣ 13 ରେ ନା 13 ପେଣ୍ଡିଂ ଅଛି?
ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଛି
13 ମାନେ ରିଭର୍ସ ଗ୍ରାଣ୍ଟ ହେଇ ଯାଇଛି
ନା ଏଟା ଲିମିଟେଡ वन ମେଣ୍ଟେନାନ୍ସ
ଏତେ ଟଙ୍କା ଆପଣଙ୍କର ଠିକ ଅଛି ଏଟା ଆଉ ଗୋଟେ ଦିନକୁ ଆସୁ petitioner not opposite party Mr. RB Mishra None appears for the petitioner. The matter shall be listed for admission in the week commencing 10/8/2024. It's a 3/8. ଆପଣ ତ କଣ ଏତେ ଆଷ୍ଟ୍ରୋନୋମିକାଲ ସମ୍ କହୁଛନ୍ତି 18 ଲକ୍ଷ ନା କେତେ କହିଲେ?
10,80,000 ଟଙ୍କା ଦବ।
ତ କଣ ଆପଣଙ୍କର 25 ମସିହାରୁ ଏତେ ଟଙ୍କା କିନ୍ତୁ ଡ୍ୟୁ ହେଇଗଲାଣି ବର୍ଷେ ଭିତରେ? ଡେଟ୍ ଅଫ୍ ଆପ୍ଲିକେସନ କେବେ?
13/12/2021।
5 ବର୍ଷ।
ଆଜ୍ଞା।
ବର୍ଷକୁ 2 ଲକ୍ଷ ଟଙ୍କା?
20,000 ଟଙ୍କା ମୋ ଥ୍ରୋରେ 2,40,000 ବର୍ଷ।
ରଖନ୍ତୁ ତାହେଲେ କେବେକୁ ରଖିଲେ ଆଜ୍ଞା? 27/7। But 3/8 ରେ ବି 82 ଟା ଅଛି ବୋଲି ସେ ରଖୁଛନ୍ତି actually. That is the purpose. Yes, next.
34.
ଲେଖି ଦେଇଥାନ୍ତି।
May I please the lords?
Yes, yes.
My lord, here I am for the petitioner wife, and my lord, we are challenging the order which was passed by the learned family court Bhubaneswar in CP number 19/25.
Yes.
This, my lord, this criminal proceeding has been dismissed ex parte against the opposite party.
Yes. Start. Kindly speak to the microphone.
My lord, this criminal proceeding has been dismissed ex parte against the opposite party.
Dismissed ex parte against the opposite party.
Yes,
So then
my
why
lord.
the petitioner is before this court?
My lord, here we are for the enhancement of maintenance, my lord.
Enhancement.
Yes, my lord. My lord,
Ground seeking enhancement.
Ground, my lord, the lower court did not, my lord, we are challenging that order. Dismissal order.
The judgment is dated
15/11/2025.
during scanning.
Sorry, my lord.
Yes, how do you sustain this, Mr. Mahanti? Yes. What is the logic? What is the reasoning? Straight away, because we are already running short of time. I have crossed the time almost. Yes. To sustain this judgment, how the learned judge has proceeded? What is the reasoning given by the court? You confined to that much.
Your lordships, kindly see page 16, para 6.
And there,
Yes,
and there, and after reading that only, I'm asking you. You are seeing my hands because yes.
Your lordships, he has stated. Yes,
kindly read that.
Your lords, para 6. Page 16, para 6. The sufficient unassigned evidence of PW1 that it is opposite party who has neglected and refused to maintain the petitioner having sufficient means. As per the petition,
kindly stop there. So, common understanding of English. What is that sentence would lead to? Sufficient unassailed evidence of PW1 that it is the opposite party. Opposite party is the husband.
Yes.
Who has neglected and refused to maintain the petitioner having sufficient means.
Your lordship, he has stated.
So then how the claim can be rejected?
Your lordship, he has particularly stated that the getting rupees 2 lakhs from the business of the contractor, and thereafter you are earning of rupees 1,60,000.
Whenever you are reading a judgment, don't use your words which are not there.
Not a single document. Yes, your lordship, not a single document he has filed.
As per
the petitioner, the opposite party is a contractor and earning rupees 2 lakhs per month. He is also earning rupees 1,60,000 per month from landed properties and building and leading his life luxuriously. But she has not relied upon any documentary evidence in support of her claim.
Kindly read further. Or I'll every time have to every sentence please read the chapter 5 hai like this. Padhantu.
The petitioner has filed a disclosure statement of assets and liability, which reveal that she is 59 years old. Her qualification is a graduation. Their date of marriage is 21/1/1991, and since 25 to 2014, they are staying separately. And her month expenditure is 50,000. She has mentioned in her income as nil.
55,000.
Income is nil in her statement. She also admitted that she was awarded 10,000 as interim maintenance in APL number. Thereafter, she filed a lodged
Sir, please read, sir.
Yes.
Okay, every time every sentence you are saying something else.
Yes.
Complete reading.
Is 10,000 as interim maintenance in APL number 8,000.
Whatever be the number,
2020 by the Honorable High Court. Accordingly to her, the opposite party is earning rupees 2 lakhs per month from contractor work and 1,60,000 per month from landed properties and buildings. Both the children of the parties have already attained their majority. She is the only person being unable to maintain herself, having no dependent, since she was awarded with rupees 10,000 per month as interim maintenance by the Honorable High Court. I do not think there is any necessity to award further maintenance to the petitioner. Hence,
So what is the finding that she is not entitled? What is the evidence?
Evidence, your lordship, the
That APL order 10,000. I'm not asking you. Please try to find out the evidence. What the Lord Trial Court has relied on. The family court. 10,000 you are receiving every month.
My lord, they have only given 60,000 as of now, and around 80 to 90,000 is still pending.
Because it is unusual. In fact, without knowing that, even I was thinking that our APL interim maintenance has awarded, and it is not mentioned also.
in Paras, your lordship, as per the Honorable.
ଆପଣ ଆଜ୍ଞା ଆପଣଙ୍କ କେସ୍ ଟା କୋର୍ଟ ଏଭିଡେନ୍ସ ଦେଖନ୍ତୁ। ଆପଣଙ୍କ deposition, evidence of deposition, cross examination.
Which was not available to you.
You have that.
Trial is going on, your lordship.
What trial going on? Judgment ହେଲା ସବୁ trial ହଉଛି। Judgment ହେଲା ପରେ ଫେର କଣ trial ହଉଛି?
ବର୍ତ୍ତମାନ ସରିନି trial ଚାଲିଛି।
What sir, Mr. Mahanshi? Don't know what.
No, till today I have not.
Judgment 15/11/25 judgment ହେଲା ପରେ କଣ trial ଚାଲିଛି କହୁଛନ୍ତି?
other case also to
ଅନ୍ୟ କେସ୍ ରେ ପଚାରୁଛି ଆପଣଙ୍କୁ ଜଜମେଣ୍ଟ ଡେଟେଡ୍ 15/11/25 ରେ deposition evidence
My lord, I need pardon.
yes
So, this is my associate, but my power is not there. And it is later.
no, obviously but there is a purpose because if you read Mr. Das the reasoning
This one.
the reasoning is not there how the court has arrived at a conclusion.
Well, the interesting part of it, some cases here, what is happening, matrimonial sort of case, they 493, 494 and 498A, other things were there. FIR was lost, anticipatory bill was filed. There, the honorable court was pleased to direct, was to deposit 10,000 per month. This is not a award by any.
No, it cannot be, but in fact,
Conditional order, which
No.
has not been complied with.
the problem is that the honorable family, the learned family judge has dictated
Exactly.
monthly maintenance.
That is what we have challenged. That is rightly my point. Observed.
No, in that assets and liability, Mr. Mahanti,
yes.
it is not also mentioned that monthly maintenance.
Like you're asking.
Because it is the column is any other amount.
Yes, she has.
ଆପଣ ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ରିଟିନ୍ ଷ୍ଟେଟମେଣ୍ଟ ଆଉ ଏଭିଡେନ୍ସ ଏକ୍ସାମିନ କରନ୍ତୁ ଆପଣଙ୍କୁ ଆପଣ କ୍ଲାଏଣ୍ଟ କଣ ବୁଝେଇଦେଲେ ଅନ୍ୟ କେସ୍ ଚାଲିଛି ଆପଣଙ୍କର 25/11 ଜଜମେଣ୍ଟରେ ଯୋଉ ଏଥିରେ ଯୋଉ ମ୍ୟାଟେରିଆଲ ଅଛି ସେଟାକୁ ଦେଖନ୍ତୁ Ms. Radhika Hans for the petitioner. କେତେ ନମ୍ବର ଏଇଟା
34.
Mr. Vijay Kumar Mahanti for the opposite party. The matter being listed for hearing under the heading, the matter being listed for admission as is heard at some length. The learned counsel for the petitioner as well as the opposite party made their arguments. Upon hearing the learned counsel for the parties, it is observed that it is directed that the copies of the depositions and evidence of the petitioner as well as the opposite party shall be obtained and shall be filed before this court as well as circulated among the learned counsel. ଆପଣ ପାଇଁ ଯୋଉଟା ତାଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ
They will say expert, they have not reduced any evidence. PW1 will take.
ଠିକ ଅଛି ତାହେଲେ ତ still worse.
Yes.
In fact yes.
ମୋ ପାଖରେ ଆଜ୍ଞା ଅଛି ଯୋଉଟା ଅଛି
ଆପଣ ପାଖରେ ତାହେଲେ ଜଜ୍ କେମିତି ଜାଣିଲେ ଆପଣ ତ ଏକ୍ସପର୍ଟ ହେଇଗଲେ ଜଜ୍ କେମିତି ଏତେ କଥା ଜାଣିଲେ ମୁଁ ତ ଜାଣିପାରୁନି
ଆଜ୍ଞା
ଆପଣ ତ କହିଲେଣି ଯେ ଅନ୍ୟ କେସ୍ ଚାଲିଛି
ଡିପୋଜିସନ ମୁଁ ଯଦି
25/11 ଯୋଉ ଜଜମେଣ୍ଟ ହେଲା ଜଜ୍ ଏତେ କଥା କେମିତି ଜାଣିଲେ
କଲେକ୍ଟେଡ କରିଛି ଯୋଉଟା ଅଛି ମୋ ପାଖରେ କେବଳ
ଦେଖନ୍ତୁ କଣ in fact you are set expert this cannot be sustained Mr. Mahanti
entire property he has possession of
ସେଟା ଆପଣ ହାଇକୋର୍ଟ ରେ ସ୍ପିଚ୍ ରେ କହିବେ ନା ରେକର୍ଡ ରେ ଆସିବ really ମାନେ baffling for me
collected deposition your lordship
so I don't know ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି entire property ସେଟା ଜଜ୍ କେମିତି ଜାଣିଲେ ଆପଣ ତ ଜାଣିନାହାନ୍ତି expert Mr. Das ଜାଣିନାହାନ୍ତି Ms. Hans ଜାଣିନାହାନ୍ତି both all because the defendant is state expert judge ଯେତେ କଥା ଲେଖିଛନ୍ତି ସେ କେମିତି ଜାଣିଲେ how does the judge know collector କଣ କରିବେ ସେ ତ Mr. Das has rightly said that in fact looking at the judgment I forgot that it is a expert judgment but dismissed you have been said expert you have no pleadings you have no evidence then how the judge knows all these things $10,000 maintenance bill ଲେଖିଦେଲେ ସେଟା ତ କେବେ ହେଇପାରିବନି that's a condition in anticipatory bill
anticipatory bill 463
the petitioner in the opposite party into bracket if any shall be obtained and produced for consideration the matter shall be listed for admission keep it asle habo
My lord, short date may be fixed.
In fact, today it should be closed, Mr. Mahanti. There is nothing.
document upon receipt code. I have not received any document, but I have.
ଆପଣ most important document ଟା ଆଣନ୍ତୁ ସେଥିପାଇଁ ରହିଲା expert hearing your judgment ରେ ଆପଣ document ସେ କଣ ଦେବେ ସେ ତ ଯାହା ଦେବେ ମିଷ୍ଟର ଦାସ ଦେବେ अपने shots ଦେବେ the matter shall be listed as written listed in the week commencing 13/7/2026 liberty to mention
Grateful.
I have recorded that it is substantially hard. The rest of the matters state karantu.
The 35
35 I am for the opposite party. There is a
Se maguthile actually fast adjournment maguthile.
order ho jai sir.
In your absence college mu inform karibi. So Prabodh Chandra Naik put kar debe for the opposite party.
down coil is not okay.
Se college mu thera sir to sikhichi.
ଜମା ବି ବସିଛି ସେଥିପାଇଁ କହିଲେ କି କହିଥାନ୍ତି ଟାଇମ ନେଇଯାଉଛି ଆମେ ଘରୁ ଖାଇବାକୁ ପଳେଇଥାନ୍ତୁ
That is the most interesting part of our profession.
Madam, pardon to mention my item 38 millisecond. Thursday millisecond.
Thursday kariyo bani actually
Friday
since council was arguing otherwise I would not have continued hearing because there is no time.
Thursday, Friday.
38 kar diyo. 3 week re.
बहुत अर्जेंट नहीं अर्जेंट
सुनो सर एक्चुअली कौन है there is a purpose
अर्जेंट दी थ्रो
27/7 118 up to 27/7 there are 400 matters and listing and every day this situation arises because some matter phrase orders so it has to be
next week next Monday
next Monday kari hobo
मतलब Tuesday
27 रे रहिले if you are happy then 118 रे मिसियो 27 week 118 matter अछि apart from these matters specifically adjourned other matters are also listed or not it has to be
Item 40
ସେଥିପାଇଁ ସେ 38 କହିଛନ୍ତି 38 ରେ 82 ଟା ଅଛି 38 ରେ 82 ଟା ଅଛି ବୋଲି ସେ କହିଲେ 27 ରଖନ୍ତୁ ଠିକ ଅଛି
item 37 ରେ existing order ଅଛି
अच्छा
Hello, item 36 may be adjourned.
Mr. Sanjeev Chakraborty for the petitioner.
Item 40 your lordships.
Mr. Mahanti, you are ଆପଣ କଣ ପଳେଇଲେଣି କୁଆଡେ ଜଗତସିଂହପୁର ପଳେଇଲେ Mr. Vinay Kumar Mahanti for the opposite party. The learned counsel for the opposite party is present at the virtual court High Court of Orissa at Jagatsinghpur.
36
Addresses arguments. The matter is listed for hearing under the heading for admission. Paucity of time intervenes. Learned counsel for the petitioner. केबे को डेट अछि कोछ
नहीं 36 रो बोझ कोके मु 37 रो मेंशन करछि
Our 36 na 37.
आपण 37 मेंशन करछथि त नै नै आपण कर होछि 37
मोर त 37
सी भी 37
से 36 को
देखिलो त 36
पहिले कोन
ठीक मो खाली adjournment
लिखा है 37 ना भी ठीक अछि
मोर adjournment
37
is identified
adjournment petition ta thila सब
the counsel for the petition mentions the matter seeking extension of the interim direction
18/26
the matter shall be accordingly it is directed CP number 223 of 2025 so order ta pura reproduce कर देबे adjourn to a date beyond पर केते तारीख डेट कले एटा
एटा के
3/8
to be date beyond 10/8/2026 as would be convenient to the learned court in season of the matter upon a prayer being made for the said purpose the matter shall be listed for admission in the week commencing 3/8/2026
Item 40 your lordship.
yes that's one sir
मुझे 6 ରୁ 10 ରହିବି
ताले
ଝିଅର convocation କରିବନି ଯିବି ଦିଲ୍ଲୀ
Mr. Vinay Mahanti can you hear please
Yes, my lord. Date is your lordship official date.
10 से 10 beyond 10 चाहूछन तो कहले ना पूर्वरु करे पड़िबो
ଏ 10 ପରେ ତ
the matter shall be listed in the week commencing 10/7 or 10/8 adjourned beyond 17/8
My lord.
Mr. Mahanti
My lord, item 40 your lordships. This is a matter on which the government, state government has to file their counter. Till date they have not filed their counter. So there is a interim order that this man, because the certificate proceeding, the Lordship has passed the order on dated.
Mr. Vibhu Prasad Mahanti for the petitioner, Mr. Nayak, additional standing counsel for the opposite party. The matter is listed for admission, for hearing under the heading for admission. Paucity of time intervenes. The Lord counsel for the petitioner mentions the matter, seeking reiteration of the interim order dated 3/5/2026 in IA number 3049 of 2026. So, office note indicates that counter affidavit has not been filed. And AD from OP number 4 has not been received, indicating AD not received, not received, stop. Para. Accordingly, it is directed counter affidavit, Mr. Naik, how much time?
Within 2 weeks.
Counter affidavit be filed by
End of
by
this.
by 30/7/2026 upon serving copy thereof on the learned counsel for the 30/7/2026 upon serving copy thereof on the learned counsel for the petitioner. The matter shall be listed for admission in the week commencing 10/8/2026. Registry shall verify if any learned counsel has entered appearance on behalf of Registry to verify if any learned counsel has appeared on behalf of OP number 4. Yes.
Thereafter, the interim order your Lordship has passed, that the certificate.
Yes. In the interim, it is directed that para 8 repeat kar debe. But keep it rokile. Shall be adjourned beyond 17/8.
Item 38 मतलब I posted has been 27/7/26 minutes till date adjournment था मतलब
It is interim order thila ki Mr.
नहीं କିଛି ନଥିଲା मतलब ଖାଲି କହୁଛି
ସେଟା ଆପଣ if you deposit the amount interim order ହେଇଯିବ ଆପଣ ଏଠି secure କରନ୍ତୁ. You secure the amount. Nothing can be done.
still 27 था
Nothing.
27 पर था after
If you deposit the secure the amount, no interim order. Once you deposit the amount, interim order until further orders can be done. Because the whole process actually has become actually frustrating for the other side. Having a decree in there, they are unable to have anything. This court puts further difficulty by interdicting the process, staying the matter without any reason. Order 41 देखिले अपन तो चैम्बर सिविल चैम्बर Order 41 rule देखिले Order 41
my case is not order 41
अपन लेबर लॉ
24 माइल section 24 of CPs थला मिलसी acts about the
section 24 जो ट्रांसपोर्ट चाहउछनी कोन पई अपन को ट्रांसपोर्ट तो नो WBC ना
नहीं ट्रांसपोर्ट मो ट्रांसपोर्ट भुवनेश्वर टू केंद्रापड़ा मिलसी भुवनेश्वर टू केंद्रापड़ा थला
Pardon me, my
ना खाली 8 जन पर्सन था सी 27 ने सेन ऑफ डिसाइड डिस्पोज
please follow the what I am trying to understand from you. Is there any interim order you want?
No, my lords. No, interim order is not that, my lords. Not the language. 27%.
It is not. It cannot be. It is something. I thought it's a maintenance application, so I thought that.
Not maintenance.
But it is against a final order. Nothing can be done.
Then my lords fix it for Friday, Thursday. Dispose it. I'll dispose of it with a direction, my lords.
No. That date could have been disposed of. If you can find out any case law or anything, then you should address. I can close it today. So there is no time. Yes, item 36.
Pardon to mention item 36. I'm appearing for the opposite party. My lords, we have filed the wakalatnama. Your lordship may kindly grant us 3-week time to file the counter affidavit.
36 date course.
वो कौन है 3/8
3/8 week रहे से.
Much obliged, my lords.